Good afternoon and welcome. This is a regular meeting of the Sunshine Ordinance Task Force called for Tuesday, February 23rd, 2010 at 4 p.m. and beginning at 4:03 p.m. And we have the roll call, please.
Yes, Mr. Chairman. Member Craven Green.
Aye.
Craven Green, President. Member Nee.
Aye.
Here.
Here.
President. Member Cotton.
Here.
Cotton, President. Member Manny. Manny, excused. Member Washburn.
Here.
Washburn, President. Member Caneva. Caneva, excused. Member Johnson. Johnson, excused. Member Chu. Member Chu. Member Chan.
Present.
Chan, President. Member Goldman. Member Goldman, excused. Member Williams.
Here.
Williams, President. Member, Mr. Chair, we have a quorum.
Thank you. Are there any changes to the agenda?
There are no changes, Mr. Chair.
Okay, task force? Seeing none, then we have the first item, please.
The first item is the approval of December 1st, 2009 special meeting minutes.
Is there a motion?
I move that we adopt the minutes. I'll
Microphone,
second.
please.
I move we adopt the minutes. And I'll second.
Okay, moved and seconded. Is there any member of the public who wishes to comment on the minutes of December 1st, 2009?
Peter Warfield, Executive Director, Library Users Association. First of all, the link online to the minutes and other items on the agenda did not function when I last checked twice, and somebody else wrote me an email saying that they had trouble, which is to say that the links, there were not functioning links from the agenda that was online to explanatory materials. Second, I did get a look at the minutes in the office of the administrator very briefly, about a half hour ago, but I do not see a copy of that for the public out here. And so that's a very severe hampering of making public comment. I had some things to say about all of these minutes, but without a copy available online and with no copy in the room available for the public, it's an extremely unfortunate crimp in the ability of the public to comment. There were some actually serious errors in the minutes and some other things that needed to be discussed, and I would like to ask for a copy of the minutes.
Thank you.
We normally have minutes out here. Are there to be copies, a copy available for the public out here?
Mr. Clerk?
Mr. Chair, the minutes are in the packet.
Okay, but is there a copy of the minutes out there for the public to peruse?
It's in the packet that Mr. Warfield is looking at in the office.
The question, I think, was, are these minutes available in this room? And you've twice gotten no answer, Mr. Chair.
Mr. Chair, before the meeting started, Mr. Warfield came into the office and was looking at the minutes, and then he left the room. I believe he took the minutes with him. I did not see it.
Okay, is there a copy, is there a copy of the minutes now available for the public to see?
I do not see that on the table. If you want me to go check inside the room again, I'll go check.
Okay, it is, I think it's necessary, since these minutes are on the agenda, there should be a copy available for the public to look at.
While I was setting up the room, Mr. Warfield was reading it in the office, and then he left the office. I do not know whether he took it with him or not.
Okay, Mr. Warfield, do you have those minutes with you?
Thank you for asking, Mr. Chair, instead of accusing me, as Mr. Rustum has done. I do not have the minutes. I most pointedly left the book with the attention of the people behind the desk in the room so that they would understand I was leaving that notebook there, and one or both of them nodded so that they would clearly understand I was leaving the book there and leaving now the room, and this was about 25 minutes to 4. So I did not take the book that is supposed to be out here and has not just the minutes, but the entire agenda packet.
Mr. Rustin?
If Mr. Warfield left it in the office and left it with other members of the department, I can go check with them. But when I went there, it was not there.
Okay, please go check. We will recess until Mr. Rustin returns. session. Mr. Rustin, thank you very much for pursuing that little matter. And Mr. Warfield, do you see in there what you were looking for? Mr. Rustin, given what transpired, let's add another minute or so to Mr. Warfield's time.
Thank you, Mr. Chair. I think I've taken the entire time up of the prior 2 minutes that you're deducting in a discussion about where and whether these minutes are available. So I think I should get the full 3 minutes. In any event, on page 9, Mr. Warfield said the task force should recommend a change if it was not satisfied with the existing legislation. The key there was that the task force was amending the legislation on its own and saying certain things could be redacted but not others. That isn't clear from that comment. On page 13, near the middle, to Member Coffin, Mr. Warfield said the issue of the minutes was brought up at a recent commission meeting, and during the course of the discussion, it was noted that Ms. Avery had said Mr. Warfield's assertion that the document did not meet the requirements of law was correct. So far, so good. Are you following me?
I am not. Is this packet page 13 or minutes page 13? Packet page 13.
Packet page 13. Sorry. He said she then went on to discuss budget issues and the subject was not revisited. The key there was that I said the body unanimously agreed to the minutes as is after I had said that they were illegal and Ms. Avery said I was right. The minutes here are incorrect and they should say clearly that Mr. Warfield said the HPC then unanimously approved the minutes that had been declared unlawful.
Okay.
I think that's all I have on these. Thank you.
Okay, thank you, Mr. Warfield. Is there anybody else who, any further public comment on the minutes? Seeing none, public comment is closed. Are there any further public comments, from the task force?
Question.
Member Washburn and then Member Coffin.
I just noted a couple of typos. One on page 10 of the minutes, the third paragraph down. The date should be 2010 instead of 2009. And then there's another, and the next paragraph near the bottom of the line, about 2/3 of the way down, he suggested that the task force find the mayor's office in violation and leave it to, rather than it, leave it to the office to present its side of the story for clarification. That's all I have.
Member Coffin.
Call the question.
Any other questions been called? We have the roll call, please.
On the motion, Member Craven Green.
Aye.
Craven Green, aye. Member Cawthon.
Aye.
Cawthon, aye. Member Washburn.
Aye.
Washburn, aye. Member Chang.
Aye.
Chang, aye. Member Williams. Williams, aye. Member Nee.
Aye.
Nee, aye. Mr. Chairman, 6 ayes.
Okay. Mr. Clerk, will you make sure that the suggested corrections are made before,
Mr. Chair, do you want it verbatim?
Well, you can, verbatim, as long as they clarify the intent, they can be verbatim or not, as long as they clarify the intent.
Okay, Mr. Chair.
Next item, please.
Item number 2 is the approval of January 5th special meeting minutes.
Okay, is there a motion to, motion
I
on?
move we accept the minutes of January 5th, pardon me, January 5th.
Motion moved, is there a second?
I second.
Moved and seconded. Is there public discussion on the minutes of January 5th, 2010?
Thank you, Mr. Chair. Peter Warfield, Executive Director, Library Users Association. I'm not clear what exactly the task force has passed on the previous motion. And I hope that in these, as in others, there will be complete clarity as to what exactly is being voted on and approved. I think the minutes are important as a record of your actions, and also when they twist or distort for any reason, often I think for no particular intention, it can be very awkward, embarrassing, and misleading, and a whole bunch of other problems. So I think sometimes small things matter a great deal. Item 5 on these minutes of January 5th has a very serious problem, and I'm wondering if anybody is reading these minutes from the task force. Because I think that you yourselves ought to be sensitive to what is being written down as the record of your actions. Item 5, the first big paragraph. Complainant Peter Warfield said he asked to see from the clerk's office a file that contained contact information about members of the Library Citizen Advisory Commission. It is the Library Citizens Advisory Committee. And I am not the president, nor did I ever say I was the president, nor do I think anybody else said I am the president. The sentence goes on after the Library Citizen Advisory Commission, for which he was the president. I do sometimes mention that I'm associated with that body, in this case because it was an issue in what they redacted and didn't redact. But I always say, of which I am a member. Anybody seeing that who wants to make an issue of it would take that, and it's happened to me in another realm, on another matter, and make hay out of what is this guy claiming he is when he ain't. I made no such claim. And that's crucial to correct. There are a number of shadings that I think are off and that I think are inappropriate, certainly from my perspective, such as, and I haven't reviewed every single word here, these are long minutes and I'm grateful for the length. On your packet, page 27, the minutes, page 4, it says that Peter Warfield said the silence from the respondent is proof that they are refusing to turn over responsive documents. I don't think I said proof. I think there might have been concern about it, but I don't think I said proof. Since the time has run out, I think I'll stop there, but I think these need to be very carefully checked. Thank you.
Thank you, Mr. Warfield. Mr. Rustin, could you note the corrections suggested by Mr. Warfield, please?
Yes, Mr. Chairman.
And include amend the minutes accordingly.
Yes, Mr. Chairman.
Further public comment?
Member of the board, I'm Ray Hartz, and I wish to state that it's very hard for us to review the minutes and see if we have corrections when they're not posted on the website until a few hours before the meeting. I understand from Mr. Rustin that this was some sort of a technical error, but unfortunately this is not the first time that materials submitted by plaintiffs in the cases and materials submitted by the respondents in the cases and the minutes have not been available online, and as such, it's very difficult to review those and take the necessary action to find out what corrections you want to put in there. So I would submit to you that it is really unreasonable that if the policy for stating minutes and putting things on there is 72 hours before the meeting, and you can't do it until 6 hours before the meeting, you're not setting a very good example for any other city board or agency.
Thank you. Further public comment? Seeing none, public comment is closed. Task force?
I just wanted to reiterate what Mr. Warfield said about number 5, since I am the chair of the Library Citizens Advisory Committee, that it will say, paragraph 2, lines 3, will say advisory committee of which he is a member.
Further discussion? Member Washburn.
I have a number of typos which I'll hand to Mr. Rustin. The only, this one matter of substance is Mr. Banks' first name. It's on page 33 of the packet, items 23 and 24. I believe he's Raymond Banks, but he's called Raymond Banks in 23 and Melvin Banks in 24. There are two Mr. Banks?
For the chair, he uses 2 different names in 2 places.
That's confusing. Okay. The other matter on page 32, about halfway down, in closing, Ms. J. Couch said the process did not include a contract, but was a certification process. The next sentence I don't really understand. Mr. Kennard said the HRC has the documents and should be dealt as other have been and not given special treatment. So I'm wondering whether he's saying that he should be dealt with as others have been, that he himself should be treated as others have been treated, or I'm not sure of the meaning of this sentence.
Okay, Mr. Rustin, perhaps you could go back and review the audio of the meeting.
Yes, Mr. Chair.
I have an idea.
Member Coughlin?
Let's see, where are we? We're on page 32, paragraph 4, which begins in closing. The second sentence beginning, Mr. Kennard. Mr. Kennard said the HRC has the documents, and I would just insert, and the matter should be dealt with as others have been, and not given special treatment. Seems to me to take care of
Okay.
it. Okay?
Member Williams?
Chair, person, I really have a concern, as was voiced by the audience, when we don't get the package the day of, or maybe the day before, we can't realistically go through the package and see the meeting. And I'm seeing some of us don't get these packages, and we really don't know what's going on. There's a lot of things in here we have to read. So I don't know if you need more help. You're doing a good job, but I do think we should get these packages in a timely manner. We're not getting them in a timely manner. Some of us are not getting them in the hall. And the minutes should be out on those tables. So I agree. We're not doing a very good job on this.
Okay, a couple of things. First of all, regarding the receipt of the packages, I believe what the members of the audience were referring to were the electronic links between the agenda and the specific explanatory items linked to each item on the agenda. In other words, an electronic version of the entire packet. Mr. Hartz is correct. Mr. Rustin told me the same thing. There were some technical difficulties that prevented those links from being established until this afternoon. It's regrettable, but it happens, and we have to do the best we can with what we have. So, hopefully this mishap will not recur. We can only hope that forces of nature and the cyber world are good to us. Regarding this particular package of minutes, I found a whole host of errors and some questionable passages, and I am not comfortable voting to approve these minutes today. Some of these are really typographical. Some, I think, do require a little bit of examination. For instance, on page 7 of the minutes, which I believe would be page 30 of the packet, under item 14, there are some sentence fragments there toward the bottom that don't seem to relate to anything else that's in that particular paragraph. I would like Mr. Rustin to go back, listen to the recording, and see if he can correct that. On page following page 8 of the minutes, item number 16. In closing, anonymous tenant said the existence of the documents unquestionable because the department did not respond. Again, that's something that needs to be reviewed. I have forwarded Mr. Rustin electronically a copy of the corrections and questions that I have, and that pretty much concludes my remarks. The chair would recommend a substitute motion that this item be continued until our next regular meeting. Without objection? What matter is continued. Would you call the next item, please?
Item number 3 is the approval of January 26, 2010 special meeting minutes.
Is there a motion? Is there a second? Moved and seconded. Is there public discussion on the minutes of January 26, 2010?
Thank you, Mr. Chair. Peter Warfield, Library Users Association. I won't say if this is incorrect, but I do wish it were a little more explanatory, and that is on item 1. It says public comment page. No number, I guess it's page 1 of the minutes of January 26. Their packet, page 42. Under public comment, Peter Warfield of the Library Users Association said a paragraph each in item 3 and item 7 do not reflect what he said. I wish it would say what I thought I said was said, so that a person reading this can say, oh, okay, fine. But there is a very serious error on page 3 of these minutes, which again I think would open someone to a range of comment and opinion. So on page 3, the third paragraph from the bottom, a little bit past the middle, it has to do with my comment. Peter Warfield said, weak excuses from city officials are offensive, insulting, and unlawful. Now, does anybody here really think that I would say weak excuses are unlawful? I doubt it. I certainly doubt very highly that I said any such thing. I might have said that they were offensive and insulting, and that these were examples of offensive and insulting and any number of other words. But for you to have me saying that weak excuses are unlawful is preposterous. So whatever it was that I said, I would love to have it in there. If you can't put it in there, then please strike the unlawful, because I most certainly would not and don't think I could have said such a preposterous thing. And again, I'm very concerned. I'm grateful for Member Williams saying that the packets are coming late. I think it's even more of an issue with respect to your substantive consideration of complaints, etc., when you don't have the packets in good time for your considered study. But certainly on these minutes, again, I'm glad that they're extensive. I'm glad for the detail that they do provide, but I think you need to be real careful about some of these things because they open people potentially to rather negative, and if it was something they had said, a justifiably negative opinion and comment. Thank you.
Thank you. Further public comment, please?
Members of the board, Ray Hartz. I would like to have the person who does the minutes be aware of the fact that there is a tendency of someone who works for a board or commission to try to protect the reputation and or the prerogatives of that board. And as such, there's a tendency in many cases to soft pedal what a person says. I am beginning to realize that if I am going to speak before any of the boards of the city, one of the things I will insist on doing is putting in the 150-word statement in the minutes, which actually summarizes what I have said, because I find that in cases, not only is it not given the emphasis that I would choose to give it, but it is in some cases put in a way that it exactly negates what I intended to say. And so I would advise any member of the city, or any citizen of the city who appears before a board or commission to summarize what you had to say in 150 words and ask that it be included in the minutes in accordance with the Sunshine Ordinance.
Thank you. Is there further public comment?
Hello, my name is Doug Comstock. I just wanted to talk first, I think the minutes are greatly improved from the way they were. I truly do appreciate it. I would appreciate it even more if I could read them. And since they're not on the table, and there may be one copy, but there are 15 people here trying to read that one copy, which makes it impossible for one person to be able to read. I really think the minutes are one of the most important things that comes out of this committee, because those are written in stone once they're approved. And they last for a very long time. And you can go back for years and years and pick up the minutes of the Sunshine Task Force to find out what really happened. And so it's really important that what really happened is really in the minutes. And it's also important that those minutes be out here on the table for the public to examine, that that's really what they said, or that there needs to be corrections. So thank you very much for that consideration.
Thank you. Is there further public comment on the minutes?
Ace Washington, leading commissioners here for the matter, but it seems as if there seems to be some small problem with your minutes or how you record them or whatever, but it seems as if since an issue is coming up has to do with public access and television and that type of thing, maybe you might want to consider on or accepting a contract with someone to come and video your meetings, and so therefore you get word for word and the expression how they say it and exactly what they're saying. Maybe something like that we could talk to the San Francisco government channel. So we're going to talk about another issue that's coming up, has to do with public access, and just thought I'd throw that on you, and might be some kind of solution to come to.
Thank you. Is there further public comment on the minutes of January 26th? Seeing none, public comment is closed. Member Cawthon?
Just wanted to, I had a,
Microphone?
I saw a typo, and also I wanted to make a comment generally. The typo's on page 45, under number 4, paragraph 2, last line. It says the family suffers at the hands of Bruges HRC employees. I think it should be rogue. And the other thing I wanted to say, I noticed the Comstock's comments on page 43 in paragraph 3, and he said now the minutes were a big improvement over what was provided when he was chair of the task force. You know, and I obviously think that everybody should have access to them. There was a glitch this time, but I just wanted to give a shout out to all the work that's done on these minutes. You know, if I had my brothers, I would get the minutes before this meeting, so we get the education outreach minutes earlier, so I could go over them beforehand. But I want to say there are maybe 3 or 4 sets of minutes that are done every month. They are very, very extensive, and I think that's really an accolade. I remember a former administrator who simply refused to do extensive minutes. So I want to give a shout out to Chris Rustin for all the work he puts in on these minutes.
Member Craven Green, Member Williams, Member Washburn.
Two substantive changes for the minutes for me on packet page 44, fourth paragraph, acting chair Craven Green, which starts. It should be acting chair Craven Green said that there was no case law on the privilege issue as to employee misconduct investigations conducted by a city attorney. That's important. There actually is significant case law on the waiver issue, but there's no case law on that narrow issue, which is a one before us. So that's should be changed. Then the last paragraph, and where the allegations have been found not to be substantial or discipline has not been imposed, justifiable redactions can be made. So it not has to be put in there twice. Otherwise, it's a total misstatement of the law.
And this is what?
This is on page 44, fourth full paragraph, starting acting chair Craven Green. Did you follow that, Chris?
Yes.
Then the other one is on page 45. The last paragraph, again, starting acting chair Craven Green, the second sentence. She also said that the department needs to give a response to the task force administrator, just so it's clear, comma, who could be prepared if the respondent has a 20-page document, 200-page document.
Okay, Member Williams.
Yes, in due respect to all my colleagues on the
Excuse me.
task force, I just want to say,
Excuse me.
yes, sir.
I'm going to ask you hold. We do have a member who's left, and that leaves us without a quorum. We are currently in recess. Okay, we are back in session. Member Williams.
As I was getting ready to say, this is a matter of records, and we're fighting to strengthen these records to get the task force amendments and more strength that's coming up on voting. And I do believe these records should be accurate. And I really don't feel like in the position, personally myself, of giving. I know there's a lot of work to be done. I know they say the budget is done, but I don't feel personally in giving shout outs today.
Thank you. Member Washburn.
I just have a couple more clarifications for the minutes. Page 43, it's item 3, it's the large paragraph beginning complainant, red star. And I believe complainant is spelled wrong. Towards the bottom, a couple of mistakes. By protecting this particular employee, city attorney's office, and rather than a semicolon, it should be an apostrophe for city attorneys, is encouraging similar acts. Act should be plural. And then the last sentence in that paragraph is completely garbled. I have no idea what it's supposed to say. Why are they protecting this particular employee under open government who definitely did things that, and then it ends.
Mr. Ruskin.
Mr. Chair, I would suggest to continue this item. I can go revisit it.
Thank you. Further comments by the task force? Yeah, I have numerous corrections of my own. I don't recall having received a Word copy of the minutes. So if Mr. Rustin could send me that in Word format, I would very much appreciate it. One thing I would note is that in item number 4 on page 45, Member Coffin's name is misspelled. This is in the item number 4, 1, 2, 3, 4, 5, 6 paragraphs. The 6th paragraph in item number 4. I would also ask that Mr. Rustin take note of the the corrections requested by Mr. Warfield. If you go back and check the audio of the meeting on those items, and then make the corrections as appropriate. And there's one other matter. Again, in item 4, in the 7th paragraph, Ms. Kanya said the minutes of the January 2005 Commission meeting should be inserted after the word commission. Reflect what was said. Several times in that paragraph, the arbitrator's name is mentioned, and I thought during the meeting I heard the name Epstein. And here you have Upstein. Upstein may be correct, but if you could perhaps check with Ms. Conyos on the correct spelling of Mr. Epstein's or Upstein's surname, that would be appreciated. And again, I'll have further corrections once I receive the Word document. And it's been recommended that this item be continued and without objection. Thank you. Mr. Clerk, could you read the next item, please?
Item number 4 is the determination of jurisdiction on complaint filed by Nick Pasquarello against the Bay Area Video Coalition for allegedly not following contractual agreements with the city and county of San Francisco.
Okay. Is there anybody here who sits on the complaint committee? Okay. Well, our first job is to determine the jurisdictional matter. Is there anybody who wants to speak on it? Jurisdiction in this matter is, I think, questionable. As complainants, well, the complainant says that he wants information on security measures taken to protect information on his California driver's license, but I don't see that on the complaint itself. And that's where I think the jurisdictional question comes in. According to the summary, Mr. Pasquarello alleges that the Bay Area Video Coalition required him to provide a copy of his California driver's license to be scanned as a condition of his receiving a time slot to cablecast his programs. So, do we have any kind of public information, public records, or public meetings issue here? I think that's what we have to determine. Member Coffin?
Yeah, that was my thought. I think that Mr. Pasquarello, if he wanted to come back and file a complaint to determine what the security measures are or the privacy measures, but we don't really have the authority to rule on whether or not someone can require a driver's license for scanning. So I don't know if Mr. Pasquarello is here, but to my mind, it's the information on privacy is what he's looking for, not whether scanning is appropriate. So I would agree that we would have jurisdiction over a request for that information on privacy and security, but I don't believe we do have jurisdiction over the other matter.
Okay. The chair is going to ask, is the complainant present? Mr. Pasquarello, is you here? Please approach the microphone. Okay, we are not arguing the merits of your case right now. We are arguing strictly on the question of whether the task force has jurisdiction in this matter. And on that, sir, you have 5 minutes.
Well, in my letter of December 22nd, 2009 to Mr. Ken Ikeda, Executive Director of the Bay Area Video Coalition, I asked for protections to the security and privacy of my scanned driver's license. I never received any response. The main reason I complained to this body was just that, because I never received any response whatsoever. I thought I was entitled to some response. If they could have said, we do have it, or we don't have it. In the contract, I'm not a lawyer, but their contract says they're governed by sunshine regarding their contract with the San Francisco, with the City and County of San Francisco. And later, Mr. Threet told me that the administrative code also comes into play here. Very simply, I didn't get a response. That's the reason I complained. I mean, I thought I was entitled to a response under the sort of broad rubric of the Sunshine Ordinance, which requires public disclosure of policies that agencies doing business with the City and County of San Francisco are implementing. Again, it's not your jurisdiction, but the California Constitution, actually in Article 1 says all people are by nature free and independent and have inalienable rights. Among these are enjoying and defending life and liberty, acquiring, possessing, and protecting property, and pursuing and obtaining safety, happiness, and privacy. On that score alone, I feel that scanning my driver's license merely is a condition, which is what some courts have ruled as the First Amendment guarantee, namely showing public access programming on a public access channel. It's a violation of that First Amendment right. They would be so invasive of my privacy to demand that. I don't know that I can add to that.
Does that conclude your remarks?
That's all I really.
Thank you. You may be seated. Is there anybody here to present facts and evidence on the jurisdiction matter in support of the complainant? Seeing none, is the respondent present? Thank you. You have 5 minutes.
Thank you. My name is Christina Hodges, and I represent the Bay Area Video Coalition. And I also have a team member from the Bay Area Video Coalition here as well who can speak to some of the substantive issues. But as to the issue of jurisdiction, I think that the City Attorney's Office summarized it well, that the format of the complaint is presented makes it difficult for us to answer it. I think as to the substance, though, of Mr. Pasquarello.
Excuse me, we're not arguing the substance now. We're merely arguing jurisdiction.
Absolutely. That issues of privacy are important or questioned here, but whether or not these fall within the scope of the ordinance as described is not clear, and how the issues have been framed definitely don't fall within the scope of the ordinance. I'm happy to answer any questions that.
Thank you. Please be seated. Is there anybody here to present facts and evidence in support of the respondent on the jurisdiction issue? Seeing none, matters with the task force. Member Craven Green.
On the issue of jurisdiction, I think I have two issues here. The first issue, which we haven't really talked about, is that if the Bay Area Video Coalition is governed by 12L, then there's a procedure by which a complaint needs to be submitted to them through and mediated through the government agency that controls the money, that gives out the money. That's what the 12L provision provides, and we don't have jurisdiction to hear a complaint until that's been complied with. So that's the first issue. I think there's an interesting wrinkle to that in that the contract that was signed between the city and the Bay Area Video Coalition provides that it will be covered by the Sunshine Ordinance. If DCA 3 can address that?
I think that Jerry 3 with the City Attorney's Office through the chair. I believe that the complainant could provide greater detail on this, but I did have a conversation with him yesterday or the day before where he read to me the passage from the contract. And it appears to me that under the contract that there is an agreement with the nonprofit that they will be subject to one provision in the Sunshine Ordinance, and that is the one that provides that once a bid is accepted, that disclosure of the bid documents will become public. And that was the only provision that I understood that they agreed to.
Okay, so there's a provision in the contract that includes them in the Sunshine Ordinance with one narrow provision to protect the bids. Is that correct?
That was my understanding from the complainant.
Right, and then otherwise they would be covered by 12L because they would receive over $250,000. But there's been no complaint submitted, there's been no referral to the mediating agency here, which it's a little bit unclear to me. I guess it could be a number of agencies because they receive funds from a number of different agencies.
I believe the most
General
significant was the
services
general service.
would probably be the one. So before we could even address this issue as my jurisdiction, that process would have to take place, and it hasn't taken place. If I could ask, the representative from the Bay Area Video Coalition, would you be willing to work with the GSA to mediate this issue in terms of whether or not there are any documents that could be released here?
Ms. Hodges, please approach.
I think that we would be happy to have that conversation. I'm not sure that that this issue is even right for that because the privacy policies for BAYBAC are about to go online, and I'm not sure that we even have an issue to mediate, but we can definitely consider the path.
Thank you. And that goes to my second point. Even if this was right for our discussion, the issue is there anything within the nature of this complaint that's within our jurisdiction? To the extent you can very generously read the December 22nd letter as a request for disclosure of documents regarding the security measures that the APC will take, that arguably could be something within our jurisdiction if there was no production of those documents. But it was very vague. Basically, the letter to me was asking for them to implement privacy protections, and then let him advise him when he can review them when they're done. So really, I think on the subsequent matter, there's no jurisdiction here because it wasn't a request for documents or public information. So I don't think we have jurisdiction. I'll vote no, but I think Mr. Pasquarello can work with the Bay Area Video Coalition to make sure there aren't any existing documents, and if there are existing documents, to have those provided. But we cannot demand that the agency not collect or collect certain information. That's just not within our jurisdiction.
Member Coughlin.
Since it looks as though we're going to find that it's not, Ms. Hodges, I wanted to ask you something. It looks as though we're going to find there's not a question of jurisdiction here. I just wanted to reiterate what Member Craven said about the letter, the December 22nd letter, which is on page 54. The second paragraph from the bottom says, please advise me when I can review in person the security measures. He's talking about protection of his driver's license information. So I'm just going to ask you, do you have security measures to protect such documents?
Yes, absolutely.
And are you willing to go over them with Mr. Pasquarello?
We were hoping that we'd be able to talk with him today.
Okay, Mr. Pasquarello, could you come up a second? It seems like that's what you want, to know that there are security measures that protect the privacy of your driver's license. So are you willing, if the department will go, if the agency will go over that, those documents with you. Is that what you were looking for?
Yes, that's the purpose
Okay.
of my letter.
Speak into the microphone, please.
Yes, that's the purpose of my
Okay.
letter, to see to see what they are and to feel some level of comfort that they're going to be adequate. I'm just going to add one thing. As you surely know, you've heard of Photoshop, right? Okay. You know that anybody's picture can be put where my picture is on the driver's license and otherwise pretend to be me. It's very easy to do that. I'm frankly flabbergasted that my letter of December 22nd said certified mail and emailed to Mr. Ikeda and emailed to every member of the board, received no response. This would have all been unnecessary with a simple response. Just be responsive to my letter.
Okay, thank you. So it seems like, as we kind of backed into this, but since you people are willing to work together to get the information that you need, it seems to me that we can say, while we don't have jurisdiction, the matter has been resolved to Mr. Pasquarella's satisfaction. That would be my thought, Mr. Pasquarella.
Well,
Please be seated.
Okay.
Please be seated. Please be seated. Further comments from the task force? Okay, at this time, the respondent and then the complainant will each have 3 minutes to present any concluding remarks or rebuttals that you wish to make. This is on jurisdiction. Ms. Hodges?
Thank you. I just very briefly, on behalf of the Bay Area Video Coalition, we do take the issues here fairly seriously and our members' privacy very seriously. And while the jurisdiction question is uncertain, we are happy to have conversations with any of the members about privacy, and I'm prepared to do that now. To the extent that the issue of AVAC's responsiveness to this letter arguably falls within the scope of what this council is considering right now, I do want to point out that the letter arrived at the end of the year and in a way that was a little difficult for us to respond to in that time period. But we're very happy to have these conversations now, and glad that we can sit down and think into it. So, thank you.
Thank you. Mr. Pasquarella?
Yes, thanks for taking this far. I respect that, strictly speaking, you probably could have just dismissed the whole matter, as I think Mr. Threed's memorandum suggests, if I'm not misreading it. And again, I appreciate your willingness to help resolve this. I just need to see what they're going to show me. I certainly couldn't guarantee that I would not come back here if I didn't think that it was meeting the law. So the Sunshine Law and possibly some other ones, although that's your jurisdiction.
Thank you. The matter is back with the task force for a motion. Sure. Member
I'm just
Cost?
going to give it a shot. That I move that we find that we do not have jurisdiction, but that we are pleased that the entity, the Bay Area Video Coalition, has agreed to work with Mr. Pasquarella to provide the security information he requested.
Okay, is there a second?
I second it.
Moved and seconded. Is there discussion? Is there public comment on this matter? You have 3 minutes, sir.
3 minutes, okay, I'm sorry. Yes, my name is Ace Washington, and most of you know me perhaps. Anyway, I'm just trying to get this together, sorry. I'm here, I was downstairs on some other issues and found out about this issue. And my comments on it is, number one, I am very concerned, maybe not about the privacy of Bayback, but I'm also concerned and will be using this agency to file for information. Because as producers at Channel 29, we don't know who their board of directors is, and neither do the city and county have ever met their board of directors. And I was really curious on how the city and county would sign a contract of that magnitude that deals with a lot of public access when we cannot get public information from this board. We don't know who their board of directors is. Now, we have a listing of their boards, but we are not allowed to ask for a meeting or to see them in person. And from my understanding, even their staff members have never met their board of directors. So that equation, it kind of bothers me as a person that's historical and a person that's been at Channel 29 for 20-some years. And as a person that blew the whistle on the last carrier, or the last operators. And I'm glad that they're here so I can announce to them that I am the founding lead man of the task force, of the transition task force. And I will be at every hearing and will be involved with everything that has to do with the transition. Because it's very important. Because a lot of stuff has not been disclosed yet, with the city and county has signed off with Bayback. And that is, you'll probably see me coming here on some issues if information isn't forthcoming. So let that be the reason, and they know I'm here at City Hall. This is my stomping grounds here, so I'm just glad that they're here, and the DTIS is here. And on information, I'm glad to see their lawyers.
Please speak into the microphone, sir.
Oh, I'm glad to see their lawyers here. So I'm here just documenting this here, and I'm just a little alarmed that privacy, that's another issue here. That's something that we're going to find out about. But information is what I'm here about.
Thank you. Further public comment? This is on the question of jurisdiction of this item.
Good evening, task force members. My name is Julian Lagos. I'm a producer at Channel 29 and 76 here in the city, public access television. I do a program called Deep Politics. And I believe there is jurisdiction in this particular matter because it involves privacy and a failure of the Bay Area Video Coalition to disclose security matters regarding our personal information. And I believe they have not responded to that. I'd like to cite the Fourth Amendment to the Constitution, if I may, Mr. Chairman, which states that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. I believe the Bay Area Video Coalition is violating the Fourth Amendment protections that we have. I also believe that there is a concern regarding our privacy at the station if indeed the operator is scanning our licenses into a database. And I think that issue was raised as to whether our licenses could be used by another party who hacks their database that could be used for personal identity theft. I also would like to provide you information I have from a source that will remain private regarding what the information may be used for by Bay Area Video Coalition. I was told by a source that they may be using our private information to run background security checks for insurance purposes. That has not been confirmed, but I'm putting that out there to the task force tonight. And finally, I believe that this task force, if indeed it investigates this particular complaint, should ask the city attorney for an order directing the Bay Area Video Coalition to cease and desist from collecting our private information. Thank you.
Thank you. Is there further public comment on this item?
Good afternoon, everyone. My name is Tracy Rosenberg. I'm the Executive Director of Media Alliance. I don't want to overstate. I understand the jurisdictional concerns, and I appreciate the sort of problem-solving approach that the board has put into this situation. I do want to put out, I think there are some sunshine ordinance violations that are in process. They were perhaps not expressed correctly in this complaint, and I wouldn't be surprised if other complaints were also to be filed at some date in the future. In other words, you may see this issue come back at you. Again, what I do want to say is that I understand Mr. Pasquarello's concerns regarding his driver's license. It is certainly true that many public access centers certainly do not require scanned copies of driver's licenses. It is a somewhat invasive procedure, and I can understand why it caused him some concern. I do want to say that public access television is a municipal service, much like hospital care, much like elementary school education. It is offered to residents of the city regardless of whether they are documented or they are undocumented, and it is offered to residents of the city regardless of whether they have a criminal history or not. And these are important parts of what public access means and of the services that the contractor has been funded to provide. And I am, again, concerned with the non-jurisdictional issue of the purpose of the information and the way that it's being used. My other point would simply be that I just want to reiterate that I believe there are some 12L concerns, which will obviously have to be filed under a different scenario, but I do believe that open board meetings that are available with the time, date, and place are a basic part of the administrative code. And since we do have the representatives of the organization here, I think it might be helpful if they could be instructed to, in order to preemptively avoid another complaint, to provide the time, date, and place of the next open board meeting, so that the substantive concerns here can be addressed to the organization in a scenario where it will respond. Thanks.
Thank you. Further public comment?
Ray Hartson, I would like to submit the fact that since you have a procedure which says jurisdiction is determined in one of your subcommittees, and a recommendation on jurisdiction is supposed to be advanced to this board, it's inappropriate to hold a hearing here on jurisdiction without the information that was elicited at that meeting. It is not reasonable to say to someone, we're going to have a procedure, ask you to come in, present your case, we're then going to forward a recommendation and then disregard that recommendation by not even considering it and then make you do it all over again. What they should be here is arguing their case, and if not, they should have been told very clearly at the jurisdictional meeting whether or not there were substantive questions, and if so, what those questions were, so they would have time to do the necessary research. I am really looking at this board and its operating procedures and the little call-outs to people, because we sort of get a lot of things better than we used to, rather than the fact that we ignore that there are a lot of things you don't do, is inappropriate. Run this place right. You are a public meeting body that is supposed to determine how other public meeting bodies run, and you run your own like a circus.
Thank you. Is there further public comment?
Peter Warfield. The absence of explanatory material on the web certainly makes it, to put it mildly, difficult for somebody who genuinely wants to understand the issues and make public comment here. Another difficulty is the difficulty that I'm having right now, which I have spoken to you a number of times about previously, and that difficulty is that as a member of the public in this city and as a citizen of San Francisco, I want to attend the Board of Supervisors meeting, which is going on at this time.
Mr. Warfield, the public comment we are fielding now is on the question of the jurisdiction of this issue, whether the task force has jurisdiction over this issue. You will please confine your remark to that subject.
And so I am unable to make a reasonable public comment as I would like to, and as you know I have done in the past on issues that are on the agenda, because of the conflict in meetings and because of the lack of material online. Thank you.
Thank you. Is there further public comment on this item? Seeing none, public comment is closed. The matter is back to the task force. Seeing no comment.
I just have one quick comment that there are a lot of issues that have risen. I certainly think the 12L issue is something I'd like to look into in future times, since we have the other 12L case. I'm really up on what the requirements of 12L are, and so that's something to think about for the complainant. Also, the issue of more information regarding the content of the Bay Area video groups, the security documents, as the Women for Media Alliance said. These are things I just want the complainant to know. These are things that would be appropriate to come forward with again, and I would suggest speaking to the administrator to find out exactly how the complaint or whatever you bring to us could be phrased, because our administrator has access to our attorney to give you legal advice.
Okay. Member Williams.
Yes, I was just wondering, how did we get this far when it was brought to the complaint committee? Looked like that should have been explained to the person there instead of taking up all this time right now to ask for jurisdiction. About 12L should have been explained when it was brought to the committee.
Okay. Member Kaufman.
Yeah, I asked Mr. Rustin before the meeting what the complaint committee said, and the complaint committee did not meet on this. Everybody heard that there was no complaint committee meeting on this item. It came directly to the task force.
Okay. Member Chen.
After this, can we take a quick recess?
Okay.
Okay, I'd like to ask another question. This is the first time since I've been here that we have not, something is not going through the complaint committee. Why wasn't this one through the complaint committee? Was there a special reason?
Excuse me, Member Williams, there are a number of items that we do not run through the complaint committee. It's been the feeling on the part of the task force that there are many items that can be decided, on which the jurisdiction can be decided directly by the task force. This is not uncommon procedure.
Okay, but it doesn't make me feel comfortable. I mean, we come in here to, don't have the packages, and then you want us to vote on jurisdiction, and we don't even get the packages, so.
Member Williams, when did you, Member Williams?
Remember me, don't try to quiet me down. I am very serious about this. Okay?
I am not
I
trying
am
to quiet. I
very
really have a
quiet
question.
down. You seem to interject something every time I get ready to say something. These people have the right, as the residents of San Francisco, to ask for information. And it should, if we can't get it here, they should have gotten it before. That's all I have to say.
Okay. When did you receive your packet, Member Williams?
Yesterday.
Okay.
Yesterday evening at 5 o'clock.
Okay. That is regrettable. There's the post office the reliability of the post office these days is quite lacking, and it's very regrettable that you received your packet so late in the ballgame. And as far as the electronic posting, again, we did have technical difficulties. Sometimes it's unavoidable. There is a motion and a second to find there is no jurisdiction. And what was the second part of your motion, Member Kaufman?
Did you get that, Chris? What I said, that the task force is pleased that the Bay Area Video
Coalition
is willing to work with the complainant to inform him of their security procedures.
Okay. May we have the roll call, please?
On the motion, Member Craven Green.
Aye.
Craven Green, aye. Member Cawthon.
Aye.
Cawthon, aye. Member Washburn.
Aye.
Washburn, aye. Member Chen.
Aye.
Chen, aye. Member Williams. Williams, aye. Member Lee.
Aye.
Lee, aye. Mr. Chair, we have 6 ayes.
Okay, we have had a request for a brief recess. We will take 5 minutes. We're back in session. Because no jurisdiction was found in complaint number 10001, the merits and therefore become moot, so item number 5 is removed from the agenda. At this time, we are going to take general public comment on items not on today's agenda. Each speaker has 3 minutes.
Good afternoon, members. Peter Warfield, Library Users Association Executive Director. I do think it's unfortunate that some of the materials, and this has happened at other meetings besides this one, do not reach you in very good time. There's a lot of material to go over, and I really think that you need to take up the issue of, in a general way, the timeliness of your materials reaching the members themselves as well as the public. With respect to the discussion about what happened at the online posting, I can only say that I think these minutes are deficient. The agenda for today simply lacks a notation about explanatory documents being available. And I certainly think that that's something that the Sunshine Task Force, of all people, should have clearly indicated on the agenda. Those of us who are sophisticated and smart and know the procedure know that a little color in the item number or in the case number is a hint that there is something to click on and available. But when I look at this agenda in the printed form, and when I look on it with a link that's not functioning, there is no clue that there is any material whatsoever available related to that item. And I think that's a big mistake, and I think you should correct that promptly so that you have a clear and explicit statement about explanatory documents being available and what they are. The administrator sent to me a copy of your February 16th and February 17th referral letter to the Ethics Commission. I won't talk about the delay, in one case, more than 3 months, I believe, since this body approved the sending to the Ethics Commission. But what I do want to speak about is a format, kind of a content-related thing. These, for example, the heading on this one, February 17th, referral to Sunshine Ordinance complaint number 09042, Peter Warfield versus Public Library. And throughout the letter, the library, the representative of the library, the title of the representative of the library, and her connection to the library are mentioned. The chair signs as the chair, Sunshine Ordinance Task Force. But Peter Warfield is naked. Peter Warfield has no affiliation of any kind with any kind of a entity other than just himself. And I'm very sorry, I have spoken to the group about this, and I have spoken to the administrator about this. That's not right. The information requests come from Library Users Association, and they also go to the city librarian, not the secretary. I think you need to pay close attention to who these letters are addressed to and who you label as correspondents and complainants, because in some cases they just are not accurate. Sue Blackman is not the respondent of a library complaint. The library is, maybe the city librarian is. And please don't strip those who come before you of their appropriate relationships to entities that they have told you and represent themselves as representing.
Thank you.
Members of the task force, right hearts. I have repeatedly over the last 3 years brought up the issues that I'm going to raise again now. Number one, how can you, in any good sense of conscience, sit here and make determinations about cases where you admit that you have not reviewed the information necessary to do so? I don't really care that you want to say the Postal Service is a problem. If you can't get the packet to the members for them to review the material, how can they fairly sit in judgment on the cases? It's unreasonable. It is unfair to the participants. I would also like to bring up again the member attendance. The fact that members do not attend this meeting changes the number of votes it takes to get a determination from this board. And by not having people here at the meeting, it places an unfair disadvantage against the plaintiff and in favor of the city, because it then takes 5 or 6 votes to get something that has any effect. And if you can't get your own members to attend the meeting, or if you can't even at least get the members to send memos to you to tell you what they decided in your subcommittee meetings, I think that's unreasonable. The whole process of this thing is just really bollocksed up. You don't follow your own rules, and you're an unresponsive body in the sense that we as the members of the public can come here and ask you questions, but you are immune from answering any of those questions. You answer to no one. The only people you supposedly answer to is the Board of Supervisors, and once a year you write a very self-praising, self-aggrandizing report to them, which really does not address many of the issues which this body fails to meet. And as such, you set not only a bad example for every other city board and commission, but I think you act essentially unlawfully and unfairly. Because again, I have got a call for jury duty, and one of the things they're going to make me do is take an oath to listen to and consider all of the evidence presented to me. And I think that you as members of this board should have that same obligation. And if you didn't get your packet and you didn't review the information, you should recuse yourself out of fairness to both parties.
Thank you. Is there further public comment?
My name is Nancy Cross. I'm a party to your items 6, 7, 8, 9, I guess. And I was surprised about the kind of response when I tried to see where I could move on my concerns with the Sunshine Task Force. When I asked about it at the supervisor's office, Mr. Rostam came and he said, we have a complaint form. And I said, well, it is mentioned about jurisdiction. And I said, well, I'd like to know whether you have, and he assured that they could discover whether they had jurisdiction, I guess, by the amount the city invested in, and made some inquiries on that. I said, I'm not here to make a complaint. I want to know, first of all, whether you have jurisdiction. And when I did, he said, well, just put it down here. And I think I crossed the word complaint out because I first want to know whether you have jurisdiction. If you have jurisdiction, I might proceed with the agency in an attempt to exercise the jurisdiction. But what I got was something that was a copy of sending my so-called complaint to them, and they responded as if it's a complaint against them when I was trying to ask for jurisdiction. I want to know jurisdiction before I start asking and following what I am entitled to under the Sunshine Task Force. So I didn't get satisfaction there. I was kind of offended by the idea that I was, through Mr. Rostrom, making a complaint about people that I hadn't even addressed with them, the matter of asking for Sunshine documents. So that I was eventually told that when your meeting would be, and I was expected to come, but I didn't have any instructions about the 15 or 5 minutes or the jurisdiction first before it would come on the merits. And I certainly never did receive any copy of the agenda as such. I think all these things should be before somebody who has brought up matters so they know what you do and where to get any materials and to have them available at least at the library. Well, I happened to go to the library today and looked up again about the 2 agencies that I've raised questions about, and I found that the library has 2 different categories, the public and the nonprofit, and that was a little bit enlightening. And I saw a copy of your agenda for today, and it says it was received by the library on February 22nd, namely yesterday. Am I expected to have to follow you through the library and go the last day to find out what you may have done or how you proceed? I think that's asking too much of an applicant. I was never informed that I needed to go online in a library in order to find out what I should know when I come here. I have been a board member myself, and I'm concerned about proper jurisdiction and have informed decision-making. And informed decision-making is that you get the materials timely in advance and you can actually decide them. And if you don't get the materials timely, I think you have no jurisdiction to make the decision.
Thank you.
And I would
Please
appreciate
conclude your
your
remarks.
abiding by some of the concerns that have been expressed here.
Thank you. Further public comment, general public comment.
Members, Doug Comstock. Now for some of the good stuff. The City College has passed a sunshine resolution both on records and on meetings. Now, the meetings portion of the sunshine policy is intact. But if you were to go to City College today and ask them and file for an immediate disclosure request, you would come up with blanks because they don't know no one knows anything about it. But here's the resolution that was submitted by Dr. Greer, and she's here today. She's going to speak next. In September 28th of 2006. This is documents. It's the documents portion of the Sunshine Law. It was submitted in 2006. It then went to shared governance. It went around to several meetings, which I dutifully attended as chair of the Sunshine Task Force at that time. We were trying to fulfill our purpose to spread sunshine to other agencies within the city. Ron Lee, Dr. Ron Lee, who is the counsel for the City College, went through what I had submitted, and almost every line of it is crossed out, and his own text is, and his reasons are given for why they couldn't adopt the document policy. But it did go through shared governance. The changes were made, and it was voted on by the City College trustees. So why then can we not go there and get an immediate disclosure request? Well, it's because the documents portion was lost by Dr. Ron Lee, who is the counsel. Now, a student at City College might get away with something like that, might get away with the dog ate my homework, but for a member of the bar to lose an entire policy, and therefore what was passed by the Board of Trustees is not in effect a year later, well, it's just not acceptable. So I just wanted you to know what was going on there at City College.
Thank you. Is there further general public comment?
Good evening. I'm Anita Greer, board member at City College of San Francisco. I want to just give you a little bit of information about the ongoing battle at City College concerning the board's many attempts to implement the Sunshine Ordinance. We've had obstacles, we have had roadblocks. We are now in a good place with the new chancellor, with several new board members who are committed to helping with the Sunshine Ordinance. I look forward to the day when I can come back to you in the near future to tell you that the board has a Sunshine Ordinance in place, that it is working, and that the public is pleased, and that the documents that they request are easy and stress-free in order to get them. I'd like to thank you, the individual committee members who I have gotten support from in the past in terms of making sure that we're on the right road to implement this sunshine policy. So hope to see you in the near future with good news. Thank you.
Thank you. Is there further general public comment? I just want to say to former member Comstock and to Dr. Greer, and as one of the people who worked on the committee that worked with the Community College District, thank you for coming in, updating us on this. We hope you will continue to update us on this. and if there's any way that this task force can help move you along towards strong sunshine, by all means, let us know. Thank you very much. Public comment, general public comment is concluded. Member Craig Green.
Just a point. I just want to ask the administrator when the packets were mailed to the board members.
Packets went out Thursday evening.
Right. Because I received mine Friday, so just for a matter of public record, some of us, or I would hope most of us, received it in sufficiently in advance to allow us to read it. So just to think that was ambiguous on the record.
Member Coffin.
I want to say that I received mine on the 30th, Saturday, I think.
Mine also came on Saturday. Member Buckler.
Mine came on Saturday as well.
Member Chiam.
Well, I never received any, but I have good old iPhone.
Member Chan, is there a reason why you haven't been receiving it? Do you have an updated address to the chair, right, to your administrator? Why do you confer with the administrator, make sure that your address is correct? Because there should be no reason why you don't receive it.
Okay. Well, like I said, I don't need it. I want to go.
Right, but if you're going to say you're not getting it, then let's clarify it. And if you're saying that you'll look at it online and don't need a mailed copy, let's clarify that to save postage.
Well, the problem there is that it wasn't online until this afternoon. So we need to get that, we do need to get that ironed out. Mr. Rusty?
I have nothing to add, Mr. Chair.
Okay. Would you call the next item, please?
Item number 6 is determination of jurisdiction and complaint filed by Nancy Cross against the Law Library for not posting agendas and minutes, not providing related documents, and not opening meetings to the public.
Okay, again, there is some question on the jurisdiction of this item. I'm going to ask first that the complainant approach the microphone. Okay, the question before us right now is whether this item falls under the jurisdiction of the Sunshine Ordinance and the task force.
Point of order before we start.
Member Craven Green.
I know that I was handed during this meeting email with information from Deputy City Attorney Catherine Barnes, dated February 22nd. I just wanted to make sure Ms. Cross had seen that.
Nothing dated February 22nd. Oh, there, who was it sent from?
Catherine Barnes.
And how was she associated?
She is in the city attorney's office.
No, I have not received anything from the city attorney's office. I received something about a week ago, maybe. One said it was one of two things, and I didn't get the second thing. But I received some records from ECS itself, but they weren't completed with what they intended. But I have.
This is just on. We're talking solely about the law library issue first.
Yeah.
So just that one. Through the administrator, was this sent to Ms. Cross?
It was mailed to Ms. Cross.
It was mailed to Ms. Cross on
Yes.
the 22nd?
No, thereafter. Not exactly on the 22nd.
Was it mailed
No,
or emailed?
it was mailed not on the 22nd. It was. Yes, on Monday. It was mailed on Monday.
Excuse me, was it mailed or emailed?
It was mailed. Ms. Cross does not have a telephone, did not provide a telephone number or an email address.
All right. So did we give a copy to Ms. Cross today at the hearing?
I haven't had a chance.
Why don't you please give Ms. Cross a copy?
I have a point of order also.
Member
that-
Kaufman.
That, we're just getting this thing from Kathy Barnes.
Microphone, please.
We're just getting this thing from the attorney for the law library in the middle of our meeting. I don't have time to absorb it. It seems to me she's saying we don't have any jurisdiction over this body, but I mean, I've done a huge amount of research and read the California Public Records Act and looked at the Development Brown Act section, so, I would like to be able to absorb what Ms. Barnes has said, but I don't feel that I have time to do it justice right now, so I'm not sure if we should proceed with this today or continue it, or make sure that Ms. Cross has an opportunity to see Ms. Barnes' argument. It seems like there are a lot of moving parts here.
Are you moving for continuance?
I will move for
Before you, okay, may I?
Well, I don't know, what is the complainant thing? Ms. Ross?
Well, why don't we let Ms. Ross, through the chair, have her 5 minutes presentation at this juncture?
Ms. Cross, we are about to consider the matter of whether this complaint against the law library falls under the jurisdiction of the Sunshine Ordinance and of the task force. If you believe if you believe the jurisdiction exists, you have 5 minutes to make your case starting now.
Well, it's very surprising to me. I got a little note from the law librarian, and she said we're an autonomous agency. We're responsible to nobody, essentially. Can't imagine that something that's called San Francisco Law Library is autonomous and not connected with anything. It has no responsibility to anybody. But the reason I got into this, I have a little memo of what it's law. It's not an argumentative statement. But some time ago, I had reason to try to find out who was the board. Of the law library. I've been to other law libraries, and they post notices to their meetings, and you can find out who the members are, and you can go to their meetings. But surprisingly, in San Francisco, with 3 law libraries, there was no notice of any meetings from day to day, and they refused to give information of where their board was. And I went over to the Superior Court, and I could see that some members, maybe of the Superior Court, were on the board of law library. And I went to the courtroom of the presiding judge, and I had talked to somebody who intermediated, like a clerk there, and she asked the presiding judge, and it was maybe July or something like that, and the law says, the state statute says they're supposed to meet at least once a month. The answer was no, they had no meetings at all. I was really surprised, but this memo that I have, it's 2 pages, and on one page is what the state law says about the meeting at least once a month, and that if there are rules and regulations, that the board has to make them, not that a librarian concocts them. And then there's, of course, the city charter, which in this county is, if it contradicts it, can be controlling. Have the things from the city charter. So I have enough copies for as many people as here that would like to have a copy, and see if that's enough to go around. And you might want to take this into consideration in evaluating whether you have jurisdiction. And as far as I can see, you certainly have. It's a public agency. It's a local public agency, subject to the Brown Act and the notices, which have been. And I have pressed the law library from time to time. It's all very mysterious, and you can leave messages for the director, but the website just gives her name and her telephone number when you look it up under website. It doesn't give the names and associations of the board of directors. Now, I have persevered on this matter, and with somebody who was in a public agency and a librarian administrator, who on my behalf called her, the librarian, up and asked her for the names of the Board of Trustees. I did eventually get a copy of the number of the Board of Trustees, but it's very indirect and convoluted. There was nothing online look under San Francisco Law Library. So I called up the chairman of the board, and I reminded him, I said about the meetings. He said, once a month, at least once a month. And he said, oh, that was about all, I gave him the number of the statute, as you'll see there, what it is. And he seems quite surprised about it. But there's the law library separated from the general library, and it's got about 6 members, law members, and the mayor on the board. And then there are about 7 attorneys. And I tried to call up all the attorneys, and one of them was on leave to the Washington, D.C. to advise the Obama administration. And there were different, none of them seemed to have any idea that they were operating as something responsible to the public, and the public should have access to it. So it seems to me almost as if the law librarian the people that are named, maybe they have emails and maybe they talk personally, but they just delegate it as if the city and county law library is like their business law library in their law firm, and you just give some instructions to a librarian and she runs the show. Now, I think this is not what's right, and the city is paying, it seems, for maybe the law librarian and 2 assistant librarians, something like that, and all the books and all the rent for the thing. So I think it's a public agency, and a local public agency, that is subject to general law and the statute and the charter. The charter, to the extent that it modifies a little bit the selection of the board of trustees, because it's the city and county. It's not quite the same as other counties.
Thank you.
Thank you very much for. Are there any questions?
At the moment, no.
All right.
Please be seated.
Thank you.
Is there anybody here to present facts and evidence in support of the complainant on the jurisdiction issue? Seeing none, is the respondent present? Is there anybody here to present facts and evidence in support of the respondent? Seeing none, the matter is with the task force. This is on jurisdiction. Member Craven Green.
I think this is a very interesting and difficult question, actually. I wish I would have had the library's information a little bit sooner. The only thing I would note, in addition to the jurisdictional memorandum provided by our deputy city attorney, that under 67.3 definitions, D, policy body, there's 7. And under 7, it's any advisory board, commission, committee, or council created by a federal, state, or local grant whose members are appointed by city officials, employees, or agents. I think that potentially is relevant here. Perhaps not. I don't know if DCA Treat had a chance to look at it.
Through the chair, Deputy City Attorney Jerry Threet, I did look at it, Member Craven Green, and the key word I think there is created by grant. This board is not created by a grant, it's created by an act of the state legislature. It does delegate the appointment of some of the members of the governing board to the Board of Supervisors. Others are designated in the law that created it to be members of the Superior Court of the County of San Francisco. So I think
those are all ex officio members. Ex officio. So they're not members, or they're ex officio members.
that's not my understanding, but I'm happy to look further at it.
It's ambiguous to me, and that's how much the law library was here. It looks to me that all of the Superior Court appointees are ex officio.
Yes.
So, anyway, at least under the law regarding the county law librarians. Yeah, I appreciate that. I mean, the reason why I thought the issue of grant might be relevant is that the Board of Trustees and the law library itself is funded in large part from filing fees generated by the Superior Court.
Correct. My analysis of it was that is not a grant, but it's a direct funding of the state-created body by the state fees. If we consider that a grant, then I think many state agencies could be considered, if there's appointments by the Board of Supervisors, it could be considered subject to the local sunshine ordinance.
That's an excellent point. Perhaps that's too broad of a definition. It's also strange because the other issue that I found was strange or interesting, maybe this happens a lot, is that you have a body that's created by state law, you have subsequent amendments in the state law, which affects maybe the county, maybe city and county, and then you've got the charter, which also enacts it in a way. It really just codifies it, I guess could be the argument, because it says the charter itself basically provides that there's a section 8.103, the law library. Essentially, the law library shall be under the management and control of the Board of Trustees as established by the Act of the Legislature approved March 9, 1870. So it does seem to me that this is a really complex issue, but I tend to agree with DCH Reed's analysis, that this is probably a body created by state law, and therefore wouldn't be under the jurisdiction of this body, unless there's something I'm missing. If it's not created by a grant, I think.
I would add that although my analysis is not subject to the jurisdiction of this task force, that it still appears to be subject to the Brown Act. So a complainant would still have remedies under the Brown Act, including going to court to try to enforce provisions of that law.
No, I agree with Mr. DCH Reed on that this is what the real question here is whether we have jurisdiction to hear a complaint against it by this local body. That issue, I don't think we have jurisdiction, but I do agree that this is a body subject to the Brown Act, and so to me, there would be quite a good case to go to Superior Court to seek a remedy with attorney's fees.
Member Crawford.
I just had some more comments on the law libraries is at 401 Van Ness. Apparently they rent to somebody. If they are a state body, they're covered by the California Public Records Act. And the California Public Records Act does permit, it does say that public records are open to inspection, and that the agency, the entity has to help the requester to find to inspect and obtain the documents, or send them to them electronically. So while we specifically may not have jurisdiction to rule on a matter that's covered by the California Public Records Act, I think as the Sunshine, as enforcers of, or as adjudicators of the Sunshine Ordinance, which is a stronger act than the California Public Records Act, we certainly could advise the complainant that she could make a request under the California Public Records Act to get the document she wants.
Member Craven Green.
And as to Ms. Cross's initial comments, I think made in general public comment about the fact that she didn't necessarily want to file a complaint, she just wanted a resolution of this issue. Was there jurisdiction by this body over this interesting hybrid entity across the street? And so I think in the future, if our administrator can, I don't know, work with the city attorney to try to flesh this out, it may be a situation where the full analysis can only be done if a complaint is filed. I don't necessarily think that calling somebody a complaint means that, you're complaining and you've been axe to grind. It could be that just in this situation, you're trying to find resolution of this question, which hasn't been, to my knowledge, addressed before, at least by this body. So, I think in the future, if the administrator can work with folks to try to get an analysis about whether or not there might be jurisdiction over something, an issue that the DCA feels that should be aired at the full hearing, then of course we can bring it forward as a complaint. But if there's a way to get informal resolution of that, that would be, I think a good option to explore as well.
Member Crawford.
I just wanted to ask the city attorney, does the, it seems like it's a state agency since it was created by the state in 1870, does the requester have a right to get documents under the California Public Records Act?
Through the chair, Member Cawthon, I didn't do a full analysis of this because the first question was whether there was jurisdiction here, so I didn't feel it was warranted to spend the amount of time to come to a complete conclusion. But it does appear that there is, that the Public Records Act and the Brown Act do apply to this body. I would say that I would call it a state-created local district, special district, and it's more the nature of that, and those two laws do apply to those local districts. So it does appear to me that they should comply with those two laws, and there are remedies available to a complainant.
What are they? Because she can't get the remedy here.
Well, I think under both acts, you can go to Superior Court and file a writ of mandate and get attorney's fees. If you're successful, that would require the agency to comply with those requirements.
Okay, thank you.
Okay. At this time, the complainant, if you wish, you can have 3 minutes to present any concluding remarks. The chair will again note that the respondent is not present.
I would like to request that the Sunshine Task Force, in response to my inquiry, give me a written statement of the basis of its decision, not simply, we're not taking jurisdiction, but say we've analyzed it and we find these things on the basis of our staff and the written material that I provided, I guess. You can maybe acknowledge that. And there doesn't seem to be any debate about what the law says. It's a matter of your concluding in relation to your jurisdiction from undisputed law, you might say. And it would be very helpful to other people. And you might cite it another time if you get into this particular quagmire. And that it would be valuable to the public to have that on record as a finding and conclusion from your Sunshine Task Force, rather than having to just deny mine and then have to go through another one without any precedent that could help other people.
Thank you.
I have a comment for Ms. Cross. Ms. Cross, I think we have agreed, even though we specifically don't have jurisdiction, we have agreed that there are two state laws that do have jurisdiction. One is the California Public Records Act, the other is the Brown Act, which has to do with public meetings. So I would make a request again under the California Public Records Act, and the code sections that I pulled out for you are 6253, which says public records are open to inspection. There's 6253.1, which says the agency must assist the public to inspect and obtain records. And then there's 6253, I can't read it, but it's another section that says they must make the records available electronically if asked to do so. So that you could make the request under those statutes and then see what they do. Because it's very clear they are a state agency. I don't agree with the woman who said they have no jurisdiction and they're not responsible for
They're
anybody.
freelance agencies.
Doesn't make any sense.
No responsibility. I think you're right. I brought one Brown Act thing and I got a judgment, and then somebody was defending the agencies that were doing wrong, and he called me a vexatious litigant, and I've never been unable to
Ms. Cross, please
get
be
that.
seated. Please be seated.
So it's
Please be seated.
be seated. I would say it's not quite so easy to.
Please be seated.
Thank you.
Ms. Cross remains seated. I do have an additional comment that I'd like to make. Please be seated. Your initial question was, you wanted to know initially whether this task force and whether the ordinance had jurisdiction over your request. And rather than asking the task force clerk that question, it might better be directed to a member of the city attorney's office. Also, there are a number of nonprofit organizations based in the Bay Area or near the Bay Area that focus on freedom of information issues. One is Californians Aware, one is the First Amendment Project, and the other is the First Amendment Coalition. All three of those are excellent places to go to address that particular question that you had. Is there a motion? Is there a motion on the jurisdiction question?
I would move we find the jurisdiction.
Is there a second? The chair will second. Is there public discussion on this item? Seeing none, public comment is closed. Is there further comment by the task force?
Yes, yes. Ms. Cross, thank you very much for coming, but I would take up on your suggestion that you get a letter from this task force of what we did find to you. All right. And I know you were writing pretty fast, and Member Kaufman was calling out the numbers, so maybe you could talk to her afterward if you're still here and find out that information. Or have Mr. Rustin write your letter what we decided here and what we said to you and cite those numbers. Okay, thank you very much.
Member Crossan?
I would just point out also that the, what we have said today will be in Mr. Rustin's full minutes.
They might be in the minutes, but since some of them are not getting the minutes and the public is not getting the minutes, I would like to see her get a letter.
Thank you, I would appreciate that very much.
And to actually take on those associations and talk to them too. Very.
I didn't get that.
Oh, the associations that the chair said, follow up with them.
Californians aware of the First Amendment Project and the First Amendment Coalition. Okay. Further comment by the task force? Roll call, please.
On jurisdiction, Member Craven Green.
Aye.
Craven Green, aye. Member Cawthon.
Aye.
Cawthon, aye. Member Washburn.
Aye.
Washburn, aye. Member Chan.
Aye.
Chan, aye. Member Williams. Williams, aye. Member Nee.
Aye.
Nee, aye. Mr. Chair, there's 6 ayes.
Thank you. Because jurisdiction has been ruled non-applicable, item number 7 is pulled off the agenda. That would be the merits of the actual complaint. Mr. Clerk, can we have the next item, please?
The next item is a determination of jurisdiction on complaint filed by Nancy Cross against ECS Sanctuary for not posting agendas and minutes, not providing financial records, and not opening meetings to the public.
Okay. Is there a motion on the jurisdiction of this matter? Mr. Clerk, do you know if there's been, if jurisdiction here has been contested?
No, Mr. Chair.
Okay.
They haven't contested jurisdiction.
Member Craven.
I believe if we read the packet,
There is a statement that we do have jurisdiction. It's on page 68, paragraph, bottom paragraph, line 3.
Okay, but that statement is not from the respondent.
no, that's from our jurisdictional amendment. I think the issue here again is the 12L issue, unless I'm missing something, maybe DC3 can explain, but the ECS is here, so why don't we just go ahead and ask ECS if they're contesting jurisdiction?
Hi, I'm Karen Renaison. I'm the Associate Director of Episcopal Community Services, and we are not contesting jurisdiction.
Thank you. In that case, is there a motion to accept jurisdiction?
We accept jurisdiction on this item.
Moved and seconded.
A second.
Moved and seconded. Discussion. Is there public comment on the jurisdiction issue? Seeing none, public comment is closed. Just further discussion. Roll call, please.
On jurisdiction, Member Craven Green.
Aye.
Craven Green, aye. Member Cawthon.
Aye.
Cawthon, aye. Member Washburn.
Aye.
Washburn, aye. Member Chan.
Aye.
Chan, aye. Member Williams.
Aye.
Williams, aye. Member Lee.
Aye.
Lee, aye. Mr. Chair, we have 6 ayes.
Okay. We will now hear the merits of the case. Ms. Cross, please approach the microphone. We are now arguing the merits of your complaint, and you have 5 minutes.
As indicated earlier, my two maybe I haven't said both of them, but it's the same way on both of them. I asked Mr. Rostrom, after a little discussion with him, that jurisdiction was of the essence, by his view, that he would determine jurisdiction, but it's you that's determining jurisdiction, and maybe I didn't remember exactly what he said. But wasn't making a complaint that they had refused records. I was asking whether they were subject to the sunshine ordinance, and then I would make the request for what I want, if you said yes. And I'll tell you the kinds of things I want and see if they're contested by Ms. Gunison, and maybe we can see that things are resolved. One of the things I would like to see is the statements, conflict of interest statements of the Board of Directors members. Is that something that I can ask for in the sunshine ordinance? Yeah, can I ask for the time and place and notices of their meetings reasonably in advance? I got something yesterday about their next meeting coming up. I don't know if it's in March, but I know at one time I talked to the director. When I mentioned, it seemed to me at the headquarters there seemed to be a meeting in the building and one evening, and I said, "Is that your board?" And he said, "No, that's a class that we have for clients. But our meeting's coming up." And I said, "When and what time?" And he said, "Well, I'll let you know," but he didn't let me know. So maybe I have a right to know in advance, and I should be able to get informed, not just by meeting people on the street. If that is disputed, maybe we can, I'll make the request. The conflict of interest statements is special interest to me, and I'd like to have the contact information for all the members of the Board of Directors and to see the current budget online. It seems that they have a 206 budget, but not current information, financial information of the sources of their income by category and major donors.
Thank you. Is there anybody here to present facts and evidence in support of the complainant? Seeing none, would the respondent approach, please? Is the respondent here? Oh, okay.
Sorry, I misheard you. Yes, Karen Price, I'm still here.
Thank you for coming. You have 5 minutes.
Sure. So generally on the merits, we think that we have complied with the Sunshine Ordinance. In your package, we've given you the notices of our public Board of Directors meetings for the last 3 years, but the copy of the notice and then the fax transmittal sheet that went to 3 different entities, to the clerk of the Board of Supervisors, to the main public library, as well as to a clerk at the Mayor's Office of Community Investment that's currently a part of the Mayor's Office of Housing. We've also included copies of the fax transmittal so that you can see that those actually arrived, as well as the agenda so that you can see that our chair called for public comment or participation in each of those meetings. So we think that we're in compliance vis-a-vis the notices. We also provided you with a copy of our policy that covers how we would respond to a public request for information. The policy doesn't specifically say that we provide a copy of our conflict of interest policy, but I can tell you and tell Mrs. Cross here that if she'd like to have a copy of that, we have no problem at all with her having a copy of it. As to getting a notice of the time and place of meetings, the truth is that we wouldn't direct that each of our meetings to Mrs. Cross. I gave her today a written slip about our next public meeting, which is this March. We're happy to post in a place that I'll talk to Mrs. Cross about privately, where I think that it would be easy for her to see the dates of our public meetings. That's a place in addition to where we're required to post by law, meaning a place in addition to the public library, to the Board of Supervisors, to the Mayor's Office on Community Investment. And I prefer to have that conversation with her privately about where that would be. And I'm certainly happy to provide a copy of our budget upon her request. It's part of our policy, it's part of the law. We'll comply with that.
Thank you. Is there anybody here to present facts and evidence in support of the respondent? Seeing none, the manager with the task force? Well, you will have another chance. Member Craven Green?
It seems to me that there's no violation here. I think it's unfortunate that what Mrs. Cross wanted was an idea about jurisdiction so that you can then make a request. It seems like most of the information that you want will be either mandated to be provided by 12L or will be voluntarily provided by ECS. So I think you're going to get the information you want, maybe not everything, because they don't have to give you everything. They're not a public entity. They're a nonprofit who's governed under specific provisions of the ordinance to provide certain categories of information. But to the extent that ECS would like to go beyond that and give you additional information, I would encourage them to do so. The more openness, the better. In a way, I'm sorry you both came here. It's an interesting issue. But now at least you have your answer, Ms. Cross, that they are governed by 12L.
Okay. Member
I
Crawford?
had a question for Ms. Grunison.
Yes.
There are some redactions in your documents. Page 84 is the first one. I just wondered what was being redacted.
I'm sorry, I don't have a copy of your packet, so can you see the number that's on the right-hand corner that I put in? Oh, thank you. What's redacted there are fax numbers of other folks. So that's our journal for that day. You see that there are a series of faxes that were sent. So I took out fax numbers that have absolutely nothing to do with our sending the fax notices of our public board meetings.
Okay. I just had a backup.
And I did that myself.
Okay. And I was pleased to see that you have a sunshine policy, which I'm now losing my place on, but I just had a couple of comments. On page 144 of our package, it says that you will provide information by appointment, and the sunshine ordinance does say that information should be provided without requiring an appointment. And that's number one. Number two is on 145 of our packet. It says, it talks about the public comment that you have at your two public meetings. And it says you must fill out a speaker card. The sunshine ordinance does require that people can speak anonymously if they wish. Just want to let you know that.
Thank you.
That's all I've got. I want to thank you again for working with Ms. Cross to get the information that she needs.
Okay. At this time, the respondent and then the complainant will each have 3 minutes to present any concluding or rebutting remarks.
Nothing else to say.
Okay, thank you. Ms. Cross?
You responded to my mention of statements of conflicts of interest or statement of economic interest. And I think Ms. Gunison mentioned that you would give me a copy of their policy. I want the copies of the statements that are made by the people who fill out the form, not simply a general policy of avoiding conflicts or something like that. And I wondered if that could be clarified so that I can obtain that information as speedily and certainly as possible.
Mr. Freed.
Through the chair. Chairman, I would have to research it further, but I believe that there are no requirements for statement of economic interest for members of the board of a nonprofit that gets city funding.
Okay. Again, I'm sorry. You still have some time left to conclude your remark.
I see. Are you saying that I have no right to see actual statements of economic interest?
I'm saying I believe that there are none, that the law does not require that they file them.
Now, I understand that the city is funding the salaries of people. Say, for instance, the executive director is Kenneth Reggio, and if the city is funding his salary and he's an executive in administering city funds, do I have any right to access his statement of economic interest?
Okay. Ms. Cross, you're going a little bit astray from the complaint that we have before us. All right. Your question, I'm not saying your questions are invalid, but I don't think they are properly addressed right at this time and place. Your complaint alleges that meeting notices of the board of the ECS are not posted for public view and are not posted on the internet or in the public library. That's your complaint. You will please, confine your remarks to that complaint.
I don't remember that I limited it quite that way, but I would like to get this substantive response, if possible, as to whether I have right under the Sunshine Act to ask for statements of economic interests of people that may be salaried through the city's fund.
Okay, this is not the time. This is not the proper time or place to address that question.
I have to make another request to the Sunshine Task Force for that. If they refuse,
You can ask. You can address that question to the city attorney, or you can address it to perhaps one of the nonprofit organizations that I mentioned before.
well, I don't like to go
Right
through
now-
some
well,
other organization.
Okay, right now, we're addressing your complaint. Okay, and that complaint is very narrowly defined here.
But you won't tell me whether a subsequent complaint might be relevant to your way of handling things? If I haven't precise that particular question,
Okay, I
do
believe
you have any
you
reason
did.
why I can't?
I believe you already asked it, and I believe Mr. Fried gave you an answer.
One thing I don't understand is when you give me an alternative of going to the city attorney, my understanding, tell me if I'm wrong, is that the city attorney advises city staff and city agencies, but it does not give a response to a public citizen directly. Is that correct?
You can go to the supervisor of public records, who is in the city attorney's office.
Supervisor of public records?
That's correct.
And who is that?
I believe her name is Paula Jesson, but
Paula?
Paula Jesson, Jesson.
Okay. In the city attorney's office, okay.
Correct.
All right, I
And
think,
if she's not handling those duties at the time, somebody else should be there to act in her stead.
all right, thank you.
Thank you. Member Craven.
Through the chair, just from Ms. Cross's information, the procedure is you should ask ECS for the documents you're looking for. Ask for all of them. They will come back to you and say either the documents don't exist, or the documents exist and here they are, or the documents exist and we're not required to provide them to you. So that's your first step, is to work with the organization. Hopefully that will resolve it. If you're not satisfied with the response, you can then mediate the issue ask for mediation of the issue, and that will occur with the city organization that provides the majority of funding to ECF. If you're not satisfied with that procedure, and then I believe at that point you can seek a determination from the supervisor of records, which is 6721D of our ordinance. So that's where the issue of seeking an analysis from the supervisor of public records is. But that is, you should only go there after you've exhausted the negotiations with ECS directly.
Yes, I believe in exhaustion.
Right. Or
No, I don't quite understand.
okay, Ms.
that
Cross, I'm
third
afraid
one.
that's all we can say. I just wanted to give you some advice. You can talk to us afterwards, or talk to our administrator for further advice.
Please be
Repeat
seated.
the last third
Please be-
one, I
please be
didn't quite
seated.
hear it.
It's 6721D.
67.21D. D for David. D for David under the Sunshine Ordinance.
Under Sunshine Ordinance, okay. Thank you very much for your help.
No, thank you. Please be seated. Is there a motion?
I move to find a violation.
Is there a second?
Second.
Moved and seconded. Is there public comment on this item? Seeing none, public comment is closed. Is there further comment by the task force? Roll call, please.
On the motion, Member Craven Green.
Aye.
Craven Green, aye. Member Cawthon.
Aye.
Cawthon, aye. Member Washburn.
Aye.
Washburn, aye. Member Chan.
Aye.
Chan, aye. Member Williams.
Pass.
Williams, pass. Member Nee,
I pass, I'm not
Aye.
going to vote.
Member Nee, aye. Member Williams,
Pass.
Member Williams, I believe.
Member Williams, you must vote aye or nay.
Nay.
Member, Mr. Chair, we have 5 ayes and 1 no.
Is there a motion to find a violation? Seeing none, this matter is concluded.
Just for the participants' knowledge, what that means is that because we could not get a majority of 6 to find no violation, it just means nothing further will be done. So you won't get an order from us, but it means it's status quo, essentially. This is on the ECS issue. It just means status quo. Basically, if you proceed the way you're going to proceed anyway. So we apologize for that.
Thank you.
Mr. Clerk, could you read the next item, please?
Item number 10 is the supervisor records report.
Okay. Is Ms. Jessen present? Thank you for coming.
You're welcome.
Please give us the highlights.
Oh, the highlights. I didn't plan the highlights here. This is the members. I'm Paula Jessen, Deputy City Attorney, and I've been serving as Supervisor of Records. This is the third report I've done. I don't find anything unusual this year. I noticed, it seemed to me, just in terms of number of petitions filed, the last year was unusual. 2008 was about the same number of petitions as filed in this reporting period, whereas last year was almost twice as many, much busier, I'm not sure why. We continue to play, I think, a role of informally getting departments who may not have responded as quickly as they should to get them to respond. I think that's been a useful function. I think we've continued to provide a second look at some of these issues and certainly been able to review cases where there's a dispute over the records have been properly redacted especially, and I think that's been a useful function. Otherwise, I see the petitions this year was pretty similar to the reporting periods in the last 3 years.
Thank you. Are there any questions from the members of the task force? Questions or comments? Member Craven Green?
No questions, just comments. I mean, I think from what I've seen, it seems that one of the major utilities is that the supervisor of public records does, whether it's through the complaint being part of the petition being filed with them or through Ms. Jackson's efforts, result in departments probably paying attention and producing documents sooner than they otherwise would, which I think is unfortunate that it has to go to that, but I appreciate that. And also, in absence of procedure for this body to review withheld records, I think it's very useful to have someone like Ms. Jackson there to be able to at least do a double check as to information that's been retracted and withheld to make sure the justifications, at least in her view, were appropriate. So I think those are two very important things that are accomplished here, and do appreciate the work of Ms. Justin on this issue. Thank you.
I just want to add my thanks. This is a very thorough report and very informative, so hats off.
Thank you. I appreciate that very much. Thank you.
Okay. Is there any public comment on the Supervisor of Records report? Seeing none, public comment is closed. And I don't think any further action is required here. Mr. Rustin?
We've lost call, Mr. Chair.
We are at recess.
We've done it in the past, and Ernie did it in the past, and especially Frank Darby did it in the past and tried to at least help them. And so I'm not saying that that's...
Express my willingness to do it.
Yeah.
Stay here, but-
And it may be just a situation where I think we're going to cross that. I'm not renewing my seat. I'll be here. We're going to cross that bridge when we come to it. But, you know, from my view, it's such a matter of frustration for these departments to hire such maybe it's a question of, oh, it's going to take less for you to give an analysis. Right, exactly. I agree. And actually, listen, that I need knowledge because of the complexities of the issues. I guess from at least, I don't think people will call me directly, but what I would say is that I have an issue what I forget is jurisdictional. Many times you don't do life and track yourself. But in this sort of situation, you can't. And you should email Jerry, see if you can resolve it. I think sometimes I thought all the time, it'll go another way. But it provides a real agility to shortcut these sort of situations.
There was just one copy.
I passed it to you.
Take care, Jerry.
Okay, so my leaves my copy.
Chris, where is the copy of the city college document?
I'm looking for it.
Oh, okay, because Doug would like it back.
Yes.
Oh, we think my Williams may have it.
You say, well, that seems to be denying your fundamental right as a citizen to petition the courts to redress the grievance. But it's part of the game of attorneys to
All we have.
tell, you might say, people who are not attorneys setting up their own right. And matter of getting access to public records is not attorneys are really interested in their name and fame, you see? But there's no pay for the damages that they get fees. No? Thank you very much. Thank you. I appreciate your involvement here.
Good luck.
But I feel as we
It'll
can do
work
things
out.
together.
Yeah, it'll work
I
out.
talk them out.
It'll work out.
You have some ideas. Tell me what your reaction is.
Yeah, you used to be the chairperson. You did? Yeah.
A good one, too.
A good one, sure was. I wish you was back.
In the pioneer days of the...
At least we had some food.
Of the sunshine.
No, that's
You
the...
playing a bit like
We're not allowed. We're not allowed.
You're not allowed. I know.
Yes.
Do you have Joel Johnson's phone number?
Don Johnson's, yes.
Do you have it? I'd like to call him, not necessarily now.
Okay, I'll get it.
Call him a little later.
Right. Okay. Apparently, his housemate or somebody invited some friends over last night, and they had a party. And I do not know whether he was present or absent, but this morning he found out that his iPod and his iTunes and all the little gadgets that he had
Stolen.
Yeah.
Well,
So he filed a police report, and while he was waiting for the police to come, he called me.
oh, okay. But he wasn't actually robbed at gunpoint.
Not at that
Oh,
point.
okay.
It was taken from his home. Yeah.
It's still probably pretty upsetting.
Oh, definitely, yes.
Unlawful detainer, landlord tenant, landlord, and they're getting, he's going to rent from tenants. They'd be interested in landlord. In this case, because the way he has shelters in the city,
Mr. Rustin, what item is the group on?
Moving on to number 11.
Number 11? And everything beyond that is still on the agenda except public comment? Mr. Rustin, how much longer for your break?
Sorry?
How much longer for your break?
We're waiting for member comment to return.
Rain. It's raining now. It's going to be good in the morning and in the evening.
Going through the bedroom. At night, at 5 o'clock in the morning. And then I'm saying, and I want to see if the policy of PCS is promoting these second right?
Sue, are you ready? We're back in session. Mr. Clerk, could you call the next item?
Item 11 is the Ethics Commission proposed rules on handling sunshine complaints.
Okay. First question I would ask is, do we want to proceed with this with 4 of our members absent, particularly Member Johnson, who did submit some comments to us and might have some additional things to say? What is the preference of the committee?
I have some thoughts. I mean, this is a really important issue. It's so key to what we do. I mean, I had suggested before that we maybe have a separate meeting on this or put it early on the agenda. I just feel with only 6 members here, I don't think we do this justice. So I would suggest that we take it up another time.
Member Washburn?
Well, I agree too, so we just keep kicking this can down the road, and I know I've read it time after time after time in preparation to move on it.
Okay. Member Craven Green?
Yeah, and specifically the last meeting, they said if people have comments, get them in writing and be prepared. And so we've gone over and over again on this. Let's, I think we should just go forward. We have Member Johnson's comments in writing and we read them.
Okay. In that case, I think the first order of business is to take comments from members of the task force on this. Also, I have submitted comments of my own in writing. They're not labeled as my comments, but and that's my own mistake. But on packet page 202, notice I'm saying Croy 10-1309 memo to the Ethics Commission. Those comments are mine. Member Craven Green.
I'm happy to start. Seeing as I did not provide mine in writing, and I apologize for that, but I am prepared to discuss them. First issue, I think, is that under number 1 of the proposed guidelines, specifically on page 197 of our packet, the director be required to process and review all referrals, can only dismiss those matters in certain circumstances as set forth in the enforcement regulations. And that's the problem I have, is that, and I think it's the problem that Alan Grossman points out in his comments, is that, first of all, what are the circumstances set forth in the enforcement regulations? I believe there are some provisions in the Ethics Commission regulations which provide that in those circumstances it will be if there's absolute lack of merit, or if it's quick referral to the department shows that there's no violation. What I would prefer to have there is that I'm fine leaving that language in, but I would like to add in that if the task force suggests that if there has been a referral to the Ethics Commission on the basis of willful failure to comply with an order of determination, or willful failure to comply with the ordinance, then that shall constitute probable cause under the Ethics Commission's enforcement regulations. And in that circumstance, what that means is that it would be a formal complaint that would be subject at least to a hearing, I believe, before the full Ethics Commission. I think that's much more consistent with what we believe should be within the purview of the Commission. The next line, when it accepts such complaints, the Ethics Commission would consider the task forces. I would rewrite that and suggest that it should be when it accepts such complaints, the Commission will give considerable weight to the task force's conclusions and findings, but would also conduct its own investigation. I think there's a dispute here between what some members of this body may believe and what Mr. Grossman believes, with what the Ethics Commission believes in terms of their powers. I personally, and this may be not the position of everyone on the task force, believe that that Ethics Commission can and should do some investigation into the allegations. They shouldn't just automatically enforce, because basically they're not, the rules don't provide for them to do that. Their rules say, we get complaints, we investigate. And I think having a second investigation, when it's conducted in good faith and when it's conducted with sufficient resources, both of which predicates have been questioned, I believe, by members of the public and by some members of this body. But if that's done, I think that's appropriate. So I'm fine with leaving that language in, but would also conduct its own investigation. What I would suggest, perhaps, is that we could add in something, for example, saying task force would recommend that the Ethics Commission review the task force's conclusions and findings, as based on substantial evidence as determinative. And what that means is where there's substantial evidence is kind of a term of art in the law, and it basically means where all conflicts should be resolved in favor of prevailing parties. That would mean all conflicts should be resolved in favor of the findings made by the task force, and all legitimate and reasonable inferences would be used to uphold the findings of the task force. And if substantial evidence, whether contradicted or uncontradicted, supports our finding, then the reviewing body, which is the Ethics Commission, is without power to substitute its deductions for those of this body, right? So basically just put more meat in it and say, we believe you should look at our findings deferentially. And if, you might have gone the other way based on the same facts and conclusions, but you should defer to us in that circumstance, unless you find that our conclusions were not reasonable, right? So if they think we missed some huge issue of law or missed some huge issue of fact, they can make their decision based on that. But otherwise, they would have to basically defer or agree with what we've done. So it gives them room to still do their independent investigation. But if they find substantial evidence for what we did, they should affirm what we did. So I would suggest that to be incorporated as a standard. In Section 2, Ethics Commission will only consider intentional violations of the Sunshine Ordinance. I actually have a big problem with that. I think under 6730, I believe it's C, there's a provision that this body may make referrals for enforcement of any violation to any municipal body with enforcement powers. That's the Ethics Commission. It doesn't say willful violation, it says any violation. And I think we've had situations where, as you can see in this paragraph, the Ethics Commission says, well, we're only going to investigate willful. And we're only going to define willful as basically in violation of the city attorney's advice. So if you have the city attorney who's saying, hey, you can withhold that document, even though we as a task force have found that that city attorney's advice is insufficient, or we believe it should be contrary. I believe in that circumstance, we can have a violation of this ordinance that wasn't necessarily willful because it did rely on their city attorney, but that we found that justification is insufficient as a matter of law. So I think it's very important that we make that clear that 6730C jurisdiction requires them, what we refer to them, it requires them to investigate even a non-willful issue. I don't have really any other suggestions except number 5. I believe they've already adopted this provision that says sunshine enforcement matters will be public. I just had a quibble with, this is on page 198 of our packet, the last paragraph, second sentence of the last paragraph. Additionally, complaints, investigative files, and other documents containing information about sunshine enforcement matters will be public documents if the sunshine ordinance requires their disclosure. And I would just say, as the sunshine ordinance requires their disclosure. But it's really just a quibble with words. I think it's not a big deal. So those would be my suggestions.
This is which number last?
It's under 5, but
Under 5.
it's
What does the paragraph begin with?
under that proposal.
Okay.
It's the second sentence.
Well, as the sunshine.
Ordinance requires a disclosure. The sunshine ordinance does have some exemptions. They don't have to disclose everything. For example, if it would jeopardize an ongoing investigation, I believe, or there would be witness harassment. So there's still an ability to withhold some limited information, but everything else is required to be released. So I just think we need to change the emphasis there. And I made these some of these recommendations in reviewing Member Nee's suggestions, Alan Grossman's suggestions, and Member Doyle's suggestions. I think Member Grossman's suggestions were helpful. I don't necessarily agree with all of them, but those would be provisions, or those would be suggestions I think the task force should move to the Ethics Commission to consider.
Okay, Member Kaufman.
I just wanted to follow up on number 2. It seems like everybody who has any comment feels that the Ethics Commission should consider is actually required to investigate violations of the Sunshine Ordinance if they can't pick and choose, and they can't say it's just willful, it's just intentional. I think I agree with Member Graven. 67.30 does require them to investigate our issues. That's one of the main problems we have with it. I mean, Mr. Grossman seemed to say the same thing, and so does Member Doyle, Member Johnson. So my thought would be to change that sentence to read the Sunshine Ordinance. The Ethics Commission is required to investigate all violations of the Sunshine Ordinance.
Member Washburn, then Member Williams.
I agree with what everyone said about number 2. There are a lot of problems there. One statement that's bothered me all along is in the first provision, the sentence that begins on page 196, leads to 197. Under this proposal, the executive director would be required to process and review all task force referrals and could only dismiss those matters in certain circumstances as set forth in the enforcement regulations. And it seems to me that that's giving that individual a great deal of authority, and I'm just wondering if revising number 2 will take care of that. I'm concerned that matters could be dismissed and we wouldn't know why. I see a black hole there. I would at least hope that we would receive a report back citing the enforcement regulations that enabled a matter to be dismissed by the ED. at the Ethics Commission.
I wonder what their enforcement regulations are. So I think that whole last clause, starting with "and," gives me problems. I don't know if we can take it out, but I would like to.
Okay, I'm sorry you've lost me. Which section are we in?
Talking about page, beginning on the last paragraph of page 196, the final sentence under this proposal, the executive director would be required to process and review all referrals and only dismiss those matters in certain circumstances set forth in the enforcement regulations.
And that member.
I agree with Ms. Washburn that the part after "and" gives, makes it very murky as to what authority they have.
Okay, member Washburn, what was your proposed alternate wording?
Well, I don't have a proposed wording other than to say this needs a good deal of work here to make sure that matters don't fall into the black hole of the ED's authority, which seems to be, by my reading of this, quite large. It's not clear what these enforcement regulations are. Is the ED required to report back to us and say, well, I'm not taking this to the full commission because, in my opinion, I don't see anything here. There's no merit here. I mean, that's my understanding of how things have operated in the past, and I'm wondering.
Could we delete that part, or would we have to be more specific? I wonder what Member Craven thinks about that.
I'd like to delete this sentence.
Well, I mean, this isn't ours, so I mean, this is when we can redline it, I guess, if we've got a copy of it. But I mean, what I would say is that we can say we're concerned about the special. My point was, if it comes to the Ethics Commission with a referral based on refusal to comply with an order of termination or willful violation, that shall constitute probable cause, which does not allow the director to dismiss it. In other circumstances, I think the director might be able to dismiss it as long as written justification was provided to the task force as to why it was dismissed. So that's what I would say. That's what I would include there in the report there.
Okay, Member Williams.
I concur with
Microphone,
Member
please.
Craven Green on the side of the Ethics Commission will only consider intentional violations of the Sunshine Ordinance. Everybody's perception is different. What's intentional? I think I went back to the investigations and enforcement, and then I went to page 202, where Mr. Sancour here has the misconception. Again, he says, we do not believe that there is EC's role. We believe that EC's role is to hold city officials, employees, feet to the fire when we have found that they have willfully violated the SFSO. How are they going to let us know? As Member Washburn said, are they going to write us back and let us know? I think it should be an investigation by them too, and enforcement, and they can come back and let us know what they have done. They should just, when we send it to them, we have already gone over the merit of the case. And it's always seems to be Mr. Sinclair's perception when he comes in here that they have the last say-so. Well, if they have the last say-so, let them investigate and see what they find out. And then let us know. So really number 2 is what I was really concerned about. But otherwise, what the others have said, I was really concerned about the intentional violation. I mean, everybody's going to come up here and says, we didn't mean to do it. It wasn't intentional. So what do you mean it's intentional? Okay. So everything you said, I remember Raven Green, I concur with. I don't have any suggestion, but I think it should be an investigation and enforcement. And then if they're fine, it should be sent back to us what they found if they disagree with what we have found.
Okay, thank you. Regarding my own concerns, and some of them have already been echoed here, I may have perhaps gone out on a limb a little bit in my conclusion regarding proposed item number 5. How does the disclosure of staff investigations and internal communications compromise their integrity, regardless of when during the process it takes place? I realize, that's kind of tricky. There are going to be cases where they perhaps have a right to doing some things in confidence, in private. I was kind of floating that to see if there was any agreement among the task force members. I don't sense it, so I'll just let it drop. My final paragraph, however, I still think that has some merit. And Member Craven Green?
Well, along those lines, we have to figure out here what we want to do. I'm happy to write a summary in my spare time, trying to get all this wrapped up before I leave this body, stating what I think this body believes, but I think that you may have a fundamental difference from me, and so we might want to encompass both of those in this letter.
Okay.
Some members believe that the Ethics Commission should take our matters for pure enforcement, that there should not be any further investigation. And I think that's probably your position, trying to gather from your comments. My position is different. My position is that I believe it should give weight to our findings and adjudications, but that they are empowered to do independent investigation. So I don't want to discount other members' suggestions. So we need to come to a resolution as us six, what we want to put in, and then I will write it.
I think personally what Member Craven has just suggested works very well. There obviously has to be, ultimately, what's adopted is going to, it's the Ethics Commission that's going to have the power of adoption of these rules. What we're doing here is serving as in an advisory capacity. They have waited very graciously and very patiently for our comments. And so I think it's time to move forward. And what Member Craven Green suggests, I think, is well worth doing. Member Williams.
Chairperson, I don't think that you really went out on a limb on number 5 when you said sunshine enforcement. If I'm reading right, matters will be public. I believe they should be. Maybe you think you were going out on a limb, but I believe when going out on a limb, I believe in taking risks.
But I think
I understand what you're saying.
Yeah, the point is they should be public,
Yeah.
but the question is when.
When.
Exactly. I think that even in this task force is held for non-law enforcement investigatory files, for example, the tax assessor files, and I believe there was some code enforcement files, that those should be released, but at the conclusion of the investigation. So it doesn't, give the person who's being investigated a roadmap as to how it's being investigated so they can put up roadblocks.
That's right.
At this time, we'll take public comment on item number 11. Seeing none, public comment is closed. Member Craven Green, your offer to draft a statement on the task force's behalf is deeply appreciated. If during that process there is any way in which I can assist you, by all means, please don't hesitate to contact me. I believe that concludes this matter. May we have the next item, please?
The next item is item number 12, which is the report from the Compliance and Amendments Committee.
Yes, we heard a number of issues at our last meeting. We heard a couple of different different or determination. There was, I believe, correct me if I'm wrong, on this agenda there should have been a referral on the Asian Law Caucus matter. And I apologize for not spotting that, but I wasn't given an opportunity to look at this agenda before. Have we done a referral on the Asian Law Caucus's matter in the Mayor's office?
Madam Chair, wasn't that referred to the CAC for March?
I believe, no, I believe this, Mr. Clerk, the CAC did hear the matter at its February 9th meeting, and we agreed to refer the matter back to the Sunshine Ordinance Task Force. Let me just go over what I have in my notes here, if I can find it.
While he's looking at that, I will go on. We had some compliance. The planning department and the Department of Building Inspection, actually seems to be moving towards providing electronic records more easily and readily, and they comply with the anonymous tenants' request for electronic copies. I think that's great. I think hopefully we'll be seeing fewer complaints about that, and also that the other interesting issue that came up was that in the order of termination of Mike Dario against the Arts Commission. The Arts Commission did comply with the order of termination, but there was a very interesting discussion that the Arts Commission, which is funded by license fees from the artists who participate in the Street Artists Program, that the Arts Commission had decided because of the number of Sunshine Ordinance requests that they had been receiving, that they would have to increase the amount of license fees to the participants to cover the cost of the Sunshine requests borne by the department. And while that wasn't an issue before the Compliance and Amendments Committee, we thought it was very troubling and actually suggested that the chair refer that to the Education, Outreach, and Training Committee for a future meeting. Because I have not seen a situation where a department who's funded by different license fees can decide to increase the amount of those fees to cover the cost of its compliance with the Sunshine Ordinance. Oh, I thought that was interesting, to say the least. So that issue should be hopefully addressed by EOT in the future. And then the other thing I wanted to note, did you find your notes, Memory?
Yes, this is complaint number 09069.
Right.
My notes state that this is to be referred back to the task force with the recommendation that the matter be referred to the Ethics Commission. And this should have been heard on tonight's agenda. I will make sure that it gets on the agenda for the next regular task force meeting.
Which one was that?
This is Asian Law Caucus against the Mayor's Office, complaint number 09069.
And the only other issue that you should be aware of is that we've scheduled a special meeting to go over the amendments. Specifically, we hope to go over Articles 3 and 4 on Wednesday, March 3rd, 4 p.m. If folks want to attend, members of the public should attend, and we're trying to get this wrapped up. There's still substantial work, unfortunately, that needs to be done because it was in such a disarray the last time around in terms of just making sure everything's compatible and making sure we really want to go forward with what we have. So we're going to try to wrap that up, if not next meeting, then the meeting after. But everyone's encouraged to participate and get the word out about the amendments that they are moving forward, and hopefully we'll get them wrapped up.
That's March 3rd.
March 3rd.
This will be a special meeting of the Compliance and
And then
Amendments
where can
Committee.
we find the amendments online?
The amendments, you can ask Chris. I think we have a link that for the most recent proposed amendments. I don't know if it's been updated.
Through the chair, no, it hasn't.
I think Chris and I are going to go over one suggestion tonight that Chris needs to work on from the last meeting, and once that's done, if tomorrow you could post them online, and if they don't have a copy, you should be able to get them from the homepage. That concludes my report, and I invite any other members to comment.
I have I have nothing to add. Okay, that concludes item number 11. And
12.
I'm sorry, item number 12. And Member Coffin, it would be a good idea, I think, to follow Member Craig and Green's suggestion regarding license fees charged by the Arts Commission.
Okay, can we put this on the agenda? The issues?
For the students.
Right, you just would have wanted to invite a representative from the Arts Commission to come and speak and want to notify Mr. Rodario that it was going to be on the agenda.
So put Arts Commission, put Mr. Rodario versus Arts Commission, increasing artist fees.
I wouldn't put it as a complaint because it's not a complaint. I would put it as a discussion on fee provision, or a discussion about license fees used to pay for responding to sunshine requests by the Arts Commission. Might be an appropriate way of discussing it. Because it's not a complaint
Well,
yet.
the issue is that they want to raise artist fees in order to fund their operations. So you put in somewhere, I'll put in somewhere about increasing artist fees.
Artist
Artist
license. It's
fees.
license fees.
Okay,
It's licenses.
artist license fees.
Yes.
Can we have the next item, please?
The next item is the report from the Education Outreach and Training Committee.
Okay, a couple of things.
Through the chair.
Microphone, please.
We've been working with doing outreach presentations, and we had a good one before the Central Station Police Community Relations meeting the other night, and we're scheduled to speak before the Sunshine to the Coalition for Safe Neighborhoods and North Beach Neighbors, and we're sort of cool, and we also have the Shelter Monitoring Committee whenever they get a quorum. We're sort of cooling it because we don't want to get too many of it. It's too much work. But we've been very successful, and people seem to be pretty interested in hearing about the Sunshine Ordinance. At the meeting, we Warfield versus the Historic Preservation Commission, we determined that the commission had in fact changed its minutes to reflect what the ordinance requires, and we're sending them a letter telling them that we hope they will continue to provide minutes in that expanded form. We also concluded the matter of the complaint against the mayor's office for failure to provide some document. I can't remember what it was. We found that the document had been provided. I think it was
Japanese tea gardens. The Japanese tea garden.
Japanese tea garden fees, fee increases. So that matter has been settled. The one that we forward to the CAC has to do with the attempt to, we found that a passive meeting body was a public body and should have open meetings. DPH's Department of Public Health's response was that, well, they haven't had any meetings recently, and they didn't appear at our meeting. So we found that was not a sufficient response. So we found a violation for not coming to the meeting, and we sent the matter on to the CAC. So the other issue is something that was brought up by former Chair Doug Comstock. He's got an idea to provide, this is a wonderful kind of outreach and a publicity item, to provide a Sunshine Award and a Moonshine Award. We don't know if we call it a Moonshine Award or an Eclipse Award, but the idea, which was really received quite well by the Education and Outreach Committee, had to do with a program that would start in April and would be over by June, and there would be people nominated for Sunshine Awards or for Moonshine Awards, depending on whether they are, promoting sunshine or getting in its way. And we would have liberal press conferences, and Doug Comstock, who's proposed this, has a huge press list. And the nominations, he figures nominations could be considered by a special ad hoc committee. I don't know if that's doable, since we have such problems with getting staffing, but That would take place in May 15th, and in mid-June, we put out a press release about who the awards were going to be given to, and the awards would be passed out at the Sunshine Task Force, a Sunshine Task Force meeting in either June or July. So, I mean, we were quite excited about it. We thought it was a great idea. And I don't know if Jeff Comstock is still here. I have an email that he sent me. Does everybody have an email proposed with his proposal on it? In any event, I just sort of would like to get everybody's okay to move forward on this, and we can put it on the agenda of our next Education and Outreach Committee, or whatever anybody thinks we should be doing. Comments?
Member Gregory.
Just a short reaction. I think providing an award or a Sunshine Award would be a good and positive thing to reward departments who, we don't see in front of us because they're complying. So I definitely think that is a good idea. With respect to the Moonshine or Eclipse Award, I'm just not sure. I know that other organizations do that, or advocacy organizations. So folks like the First Amendment Coalition often will have the Darkness Award, I believe, at their annual meeting. So I know that the organizations do that. I'm just not sure that it fits this body to be singling out someone for reprobation without an adjudicatory process. We're a semi-adjudicatory body. We come and we weigh facts and weigh evidence. I think it's one thing to commend without an adjudicatory process, but it's a totally different thing to disapprove without an adjudicatory process. So I'd love to hear Member Comstock's reaction to that. Maybe I'm being too technical, but I really think as a semi-adjudicatory body, we should be commending. I don't think that we should be disapproving unless it's in the context of a hearing.
Member Williams.
I don't think, I think what Doug had in mind, and it was just a little paperweight, a little glass paperweight with sunshine, and he had the moon, but we said an eclipse, that you're in between. And that would simply mean the people that have come here and have worked the departments, that have showed up, sent representatives, we should recognize them for even showing up. And the others that haven't shown up or haven't cared at all, they would get the eclipse. We didn't want we just said the moonshine, but it would be an eclipse that you're halfway there, to give them an incentive. I think if we give them an incentive that you're not yet there yet, but come on. So we agreed with it. And the first time that I've ever been here, that we had 5 members at our education and outreach. And I know Sue was very happy about that. That we had our members, our committee members, we had all our committee members. And please, can we go to number 14, because I got to go to a wait.
I just wanted to quickly say something. I mean, I'd like to call Doug Comstock, if he's still here.
Excuse me.
What? What's it?
We will take public comment, but
I wanted to just comment on what Member Craven said, because that was my initial reaction as well. That the Sunshine Award is great, and a little plaque, yes, you did good. I'm not sure that I felt really comfortable administering a Moonshine Award, and I mean, I don't even have to tell you who would probably go to it. There's a part of me that thinks maybe it's not such a great idea to give an award to somebody, to give a negative award to someone that we work with a lot. But the members persuaded me; they were also enthusiastic about it.
actually, we do have the right to invite speakers. So if you wish to invite Member Comstock, please proceed.
Well, I am going to invite Member Comstock to follow up on all this.
Well, members, as you know, there's a lot of frustration involved in working in this committee, and we all know what that frustration is, which is that we don't have any teeth. I think that the bright light of publicity is a very strong weapon, and it should be employed, because this task force is considered impotent. I think if you had something like this, it would be a lot stronger. People would take it more seriously if they thought that there might be a negative involved with not doing what the task force tells them to do. That's why the negative award is as important to me as the positive. It's the carrot and stick approach. Now, you may not decide to give a negative award this year. The first year, maybe you'll just give the first one. But I think that nominations should be opened. But I had proposed, and I thought I put this very clearly in the email that I sent, that nominations would be opened on around May 15th, or April 15th. But nominations would cease on May 15th. The nominations would be considered by a special ad hoc committee appointed by the chair. And then there'd be a press conference announcing the nominations. I think that has more power, actually, than the actual award, is that a press conference announcing the nominations for Moonshine or Sunshine. Then, after the announcement is made, the ad hoc committee will approve the final nominees, subject to approval by the task force, who will choose the final recipients by June 30th. So the task force would actually hold a hearing. The nominees would be invited to state their case, why they should have it, or why they think they should not have the particular award. And then the public should be invited to either support one or the other position. So there would actually be a hearing, there would be a process. And that's why I think that then the final award would be announced at a press conference, and they'd be conferred at the next meeting after the June 30th announcement. And it's important that the little placards, which are only $25 or so, be prepared and ready to go, and they not be paid for by city funds, but by internal funds that are collected by volunteers.
Thank you.
All right.
Okay. The chair wishes to apologize. We took no public comment on the Compliance and Amendments Committee report. I will invite that now. Is there any public comment on the Compliance and Amendments Committee report? Please approach the microphone. This is on the Compliance and Amendments Committee report, not the remarks of the previous speaker.
No, it's over.
Okay. There is no public comment on the Compliance and Amendments Committee. Is there any public comment on the Education, Outreach, and Training Committee report, including what the previous speaker just said?
I think it's intriguing to think of the sunshine and the moonshine, and it's a little way how you define the moonshine. If you say there's a ladder and they have quite a way to go up. Instead of pressing that they are down, you stress that they've got quite a little way to go. And I don't know if you're familiar with the law newspapers in this area, but there's there's a Recorder, is one of the newspapers, and I think it's on Friday when they have they capsule about 4 or 5 events, and they'll have an arrow up this way, an arrow that way. These things we think are really good things. We wish didn't happen, or something like that. And it's intriguing to see their viewpoint and to consider, the community kind of a judgment that seems to reflect the common reaction to what's going on in the courts, or some decision or some statement that the Chief Justice made. Is it yes or is it no in our viewpoint? So I think that is intriguing, and I believe in the power of a, you might say, comedy and initiative to make this world go without the formalities of guns at you or formal orders. So I like the general idea, and I think it can be worked out so that there would be some kind of evaluation that would be, you have a long way to go.
And I just had a final.
Thank you. Is there further public comment? Seeing none, public comment is closed. Member Coffin?
One of the things we have to work out is where these things would be heard. The Comstock proposal is that the nomination will be considered a special ad hoc committee. That's fine with me. The problem is that we're having problems getting staffing for our meetings. So, so the question would be, do we want to try and go for a meeting that would not be staffed, or try for a meeting for a committee that would, an ad hoc committee that would be staffed, or just buck it back with the Education and Outreach Committee, which would add an awful lot of time to our meetings. And to two members of our Education and Outreach Committee here now, Mr. Chan and Ms. Williams, so they might have some input on that.
Well, as if we had the luxury of additional staffing or additional staff time, the ad hoc committee might be a good idea, but that's not the case. So I would suggest that if the Education, Outreach, and Training Committee wants to take this up, it's free to do so.
Yeah, I think what we might be able to do is have a special meeting, call a special meeting for the day we have the nominations, just depending on what our agenda generally looks like. But I think it will be, it sounds like a lot of fun, and depending on Mr. Comstock's enormous press list, and also possibly the Bay Guardian to give us some publicity, and sending it to the recorder is a great idea. And if anybody can think of any other legal publication, that would be a real good place to put it. So I would just move then that we move forward with the Sunshine and Moonshine Awards and discuss it further at the next meeting of Education and Outreach.
I don't think a motion on that's necessary.
Okay.
Without objection.
Without objection.
Okay, I believe that takes us to the next item, Mr. Clerk.
The next item is the task force and committee meeting schedules. Shall the task force and its committees revise their meeting schedules to enable the task force to meet twice a month?
Any comments by members of the task force? And we saw what happened during December and January, where we had prolonged meetings because we had a lengthy list of complaints. In that case, a 2-meeting-a-month schedule might have been desirable. Would you agree?
I would say I'm not in favor of that. I mean, the Board of Appeals meeting, the Board of Supervisors meeting, sometimes meeting.
Excuse me. We have
You have to stay in the room. Yeah.
Here in the room.
Okay. Anyway, so I think it's best to just keep it as is, and if we get into a situation where there's too many, then call a special meeting.
any other member Cawthon and member Washburn?
That would be my thought. When we get a really huge agenda, that we could query the members as to whether they can make a special meeting. But I think as a general rule, two meetings a month is, tonight was a short meeting, will be a short meeting. But I agree that December and January were really there, so that would have been the time to suggest a special meeting. So I kind of like to agree with Member Craven and kind of leave it the way it is.
Member Washburn and then Member Chen?
I agree.
Member Chen?
Good idea.
Okay. One other question. Do we want to keep meeting on Tuesdays? There have been members of the public who have pointed out that we meet the same day as the Board of Supervisors. Do we want to change that? Member Williams? Member Chan and then Member Williams when she's ready.
I don't think we could, right?
Yes, we could.
We used to. Yeah, because I guess Chris said that there would be a problem to get a room.
Member Craven Green? Oh, nice. Okay. Mr. Austin?
Mr. Chair, there definitely would be problems with the scheduling for rooms, because for this room we do it on an annual basis, and if we change it there's no guarantee that you get a fixed room with the amount of committees and subcommittees that meet almost City Hall.
Okay.
If you want to push the idea, let's look into room availability first, and then only discuss it.
Member Goff?
Yeah, because, originally the Board of Supervisors were meeting on Mondays, and I forget why they changed to Tuesday. But when they changed to Tuesday, they collided with us, so maybe we could arrange, if we really want to go forward, we could go forward in the next fiscal year, whenever the room assignments are sent out, and we could ask for Monday instead of Tuesday.
I would argue against Monday, probably for the same, well, what I'm guessing is the reason that the Board of Supervisors decided not to meet on Monday, and that is that there are too many holidays on Monday.
I don't think that was the reason, but I can't remember the reason.
Okay, I think that would be my reason for opposing Monday. I would recommend Wednesday or Thursday, but that's just my own feeling. Mr. Rustin, the fiscal year is what, July through June?
That's correct.
Okay. Perhaps what you could do then is, per Member Cawthon's suggestion, see what the availability looks like for the next fiscal year.
Mr. Chair, it's not by the fiscal year, it's by the calendar year.
Okay. Maybe then, toward the end of this calendar year, say around September, when do those schedules come out kind of at a fixed time every year?
No, it doesn't. For me, example, they know that the Sunshine Ordinance meets on 4/8 at 4 p.m.
Mm-hmm.
So regardless whether or not I inform them, we are on the list automatically.
Okay. Perhaps around September then we could begin to look into the possibility of changing to a Wednesday or a Thursday.
Wednesday or Thursday. Last fourth week of the month.
Fourth week of the month, and then also perhaps the committees that meet on Tuesday could meet on Wednesday instead. That would be the second week of the month. And just, get the information, and then the task force can make its decisions based on that.
Also, if I remember correct, there are a lot of holidays on Thursdays as well.
Well, there's Thanksgiving, of course, but we don't meet that. We usually don't meet that week anyway, even when it's on a Tuesday.
Okay, Mr. Chair.
Thank you very much. Is there any public comment on the task force meeting schedule? Seeing none, public comment is closed. Next item, please.
Item number 15 is the administrator's report. Mr. Chair, we don't have anything else to add besides we have 6 complaints.
Okay. Any members of the task force have questions on the administrator's report? I have one. In item number 1, you mentioned between January 20th and February 16th, your office responded to approximately 406 calls, emails, etc. from persons requesting information regarding the Sunshine Ordinance or to mediate requests for records. And I'm curious to know how many requests did you have to mediate requests for records, and what were the results?
We have one from Kristen Homer.
Okay. Just the number of requests you have to mediate records requests.
To mediate, I think there was 3. I think
3 and
3.
Were they what have their results been?
Complainant agreed. The department responded to the complaint's request.
Okay.
And
in all 3 cases?
If you need the names and
don't need names, just want to know.
DBI is one of them.
Okay, we don't need names. I'm just curious to know how many requests you had for mediation.
3.
3, and all were mediated successfully?
Yes.
Great, thank you.
You're welcome.
Any other questions? Is there public comment on the administrator's report? Seeing none, public comment is closed. Next item, please.
The next item is announcements, comments, questions, and future agenda items.
Task Force? I do have one item. March 16, the Northern California chapter of the Society of Professional Journalists will present its annual James Madison Awards honoring champions of the sunshine of the First Amendment. That dinner will be held at the New Delhi restaurant on Ellis Street at Grant in San Francisco.
Do you know the cost?
Cost, I believe, will be $70 per ticket for non-members of SPJ and $50 for members. That's my best recollection. Chair will entertain a motion to adjourn.